file a petition to act upon the notification where by the
Mr. Counsel, we are concerned with the PCO. Now, this PCO was for your basic right was that you could have got another 5 years, nothing more than that. So nothing remains.
That's but my humble submission is that the petitioners are
There's no humble submission out here. The question is your basic right was another 5 years at best. That was subject to be considered. Nothing more. So that 5 years is over. What remains now? Are you entitled to have the PCO for eternity? Tell me. Your only right was for 5 years, which expired in 2015 and 2018. Maintenance. Compassionate ground, you apply for them before those authorities for compassionate. This court has nothing, no compassion in the.
We have applied. Almost reflected in the one that
No, nothing doing.
only one.
These matters can't remain.
Only one is
Then I will make it clear that they can throw you out. That will be more disastrous for you.
1 week that was. I'm not asking more time.
2014 matter, sorry.
1 week plus any date for confidence of any date was. There is for the 1 week plus. Right.
They are not entitled to get further extension. They will go supplement their further.
But
That says 26 of my position, para 8.7. A period of conflict would be for a period of 5 years. This would be extended for another 5 years. By the computer operator or recommendation of the division of commercial manager, senior division of commercial manager, the final order.
Where?
My page 56, my repeat the person.
Page?
It is 24.
Yes, where? Period of contract would be for a period of 5 years. This would be extended for another 5 years by the computer on recommendation of so and so. License will be for a maximum period of 10 years only, including extension fee.
Yes, ma'am. No further extension to that.
That clause I have that. Next in my petition also. There is clean hand also. That does not consider.
And that is why the court granted you some liberty. And there was some proceeding. Now you have completed that additional 5 years.
On the basis of that, the Honorable Court was used to give us in order, in which it was been asked to railway board. As long as tissue facilities will be in the railway board, but the railway station, our tissue book will not be addicted also.
Fantastic.
But it-
So why don't this court frame all these policies? What is there for the railway board to do?
but
The instant petition has been filed by the petitioners.
1 week time.
No,
1 week time. I'll convince them.
I'm not convinced.
Can you-
Your basic,
One opportunity loss. Can you
Sorry.
find loss? Only one opportunity loss. 1 week time loss. Not more than that.
sorry,
Only 1 week time loss.
the instant petition has been filed by the petitioners.
Can you consider interim order loss?
Who,
That has been passed after reviewing all the records and by subsequent.
this matter has come up for final disposal now. There's no question of an interim order will preclude this court from passing any order.
No loss. I'm
Matter ends, Mr. Counsel. I've heard you. Take your seat. You are agreed. There's a division bench. Go there. Thereafter, there's a Supreme Court. Go there. But this court is not going to go. You go to the division bench.
It's never Supreme Court loss. It's never. Can you give
The
me 1 week
ins-
loss? I'll satisfy loss. Kindly loss.
I'm not satisfied.
1 week loss.
This court is not going to be satisfied any time. Sorry. The instant petition has been filed by the petitioners. Seeking a direction that the respondent authorities should not evict the petitioners from the PCO booths. From their respective PCO booths, from the platforms from where they are functioning. The claim of the petitioner was based on clause 8.7 of the policy on allotment of booths having STD, ISD, /local, /fax, internet facility 2002. The said clause 8.7, running page 64, for the sake of being relevant for the purpose of the instant dispute, is reproduced hereunder. From a perusal of the said above, from a perusal of the above quoted clause, would show that the period of the contract would be for a period of 5 years. It was further provided that this would be extended for another 5 years by the competent authority on recommendations being made by the divisional commercial manager / senior divisional commercial manager with the finance concurrence, provided the performance of the booth operator is satisfactory and full license fee is regularly deposited during the tenure. The said clause further categorically stipulates that the license will be for a maximum period of 10 years only, including extension period, and no further extension shall be permitted. The instant repetition, in the backdrop of the above, coming to the facts involved, it would be seen that the instant repetition was filed by the petitioner at a time when the petitioner had completed the 5 years, and with an apprehension that the petitioner would be evicted from the PCO booth, which in respect of which the petitioners were issued licenses. It is further seen from the records that in respect to the petitioner number 1, the period of the initial 5 years expired on when?
Petition number 1, the year 2010.
Expired on? Expired on when?
Expired of 2015.
Huh? No. First 5 years.
So 2010.
Expired in the month of, in the year 2010. And in respect to the petitioner number 2, the period had expired in the year 2013. Thereafter, the petitioner, on the basis of an interim order passed by this court dated 15/10/2014, have been running the said PCOs. Since then, running the said PCOs. The period of the extended 5 years in respect to the petitioner number 1 stood completed in the year 2018.
15 and 18 years.
Number 1.
2015, and for the petitioner number 2 in the year 2018. Under such circumstances, it is the opinion of this court that the petitioners, therefore, cannot have any right for further extension in view of clause 8.7 above quoted. Accordingly, the instant petition therefore stands closed, as the writ petition had become infructuous. Be that as it the interim order passed on 15/10/2014 also stands vacated accordingly. Be that as it may, the petitioners herein shall be entitled to apply for the PCOs in PCOs, in the Guwahati railway station, and the respondent authorities shall, on the basis of the extent loss, consider the case of the petitioners.
But, I have filed it.
I have not seen the reply.
Item number technical 11, passing affairs.
Who? Okay, after some time, ask him to come. And where is the petitioners? Other side? Okay, you take.
Number 2.
Yes.
From joining Nagipara village member was trying to change the addresses of some of the schools to public centers and certain other establishments. Which actually belongs to the jurisdiction of another.
No, what are you asking for?
In connection with matter, in connection with that matter, the law and order.
Request for rectification of the names and addresses of various government and non-governmental institutions under number 1, Dwarka, after conducting necessary departmental inquiry. What is this departmental inquiry business?
Thereafter, the petitioners had filed a matter before the deadline.
What are you asking for? That there is an ongoing dispute with regard to the location of various government and non-government institutions situated in ward number 5 within Dwarka Panchayat under so-and-so in the district of Bozra and so-and-so since several years. Although several attempts have been made to settle the issue by holding several discussions, we have failed to get an outcome as a result of which it is adversely affecting the peace and harmony in between the villages. We, the public of the request you to kindly do the needful in this for causing a depart in the matter for settlement of what dispute?
Thereafter, my lord.
No.
Yes,
What is the dispute?
dispute is, my lord, joining village was trying to change the addresses. Some of the institutions, including.
What institution?
Health center.
They were trying to change the name.
Yes.
From what to what? Your representation is not clear. Is it clear? No, Mr. Rava.
To be under, my
Well,
lord.
Mr. Rava, tell me one thing. Is your representation clear on that? If this court couldn't understand, how will the DC understand? Or even the other side lawyer will understand?
Okay, 13 will clear.
Yes.
Memorandum received from the president and secretary of the board that allow.
You are requested to look into the matter. Yes. Then,
A copy of the memorandum received from the. Commissioning the village. You are requested to look into the matter and take necessary steps from your end, before the issue pertaining to your. And sometimes when report may be intimated to this office at an early. This was communicated to the civil Jilla Police Department. That report has not yet come.
Huh?
That report, my lord. Has not come.
so. Now, first of all, let us understand what do you want?
My lord, after.
No, from your representation, what do you want?
Since they have.
With regard to the location of various government and non-government institutions situated at ward number 5 of number 1 Bozora village within so-and-so, in between so-and-so village of Gwalpar in between number 1 Bozora and so, let's since several years. As regards some location,
They claim this belongs to Nadia Parami. Actually, it belongs to Bordora, number 1 Bordora, Nadia Parami. Because of that, my lord, all schemes are.
you are Bozora,
Yes, my lord, number 1 Bordora.
and who is Nadia Para?
Nadia Parami is a adjoining business.
And who are you? Why do you want the change in the name?
But we are being deprived of the schemes for the property.
Where is it mentioned in your petition?
Para 8.
Vera?
Para 8, my lord.
Yes, Deputy Commissioner. What we have done? That affidavit is not clear. Huh? It starts and finishes. Who is the P? Yes, madam. PNRD. What do you have to say? Fantastic.
Then it's the end of the.
You are concerned with which are the institutions? Your basic thing is there was a defacing of a particular institution where it was named as Bozora. Now somebody defaced and put it Nadia Para. And from there everything has happened. And what other institutions you are concerned? You are not concerned with anything else. Because your representation is very vague, Mr. Rabba. Very vague. Paragraph? How will the Deputy Commissioner know? Tell me. From your representation.
They have prayed for.
And why are you making the PNRD a party? Tell me. No, proper inquiry has to be based on some facts. The facts are very not clear from your representation. And why you approach this? You have made the PNRD a party. Then Jila Parishad.
Number 3.
Yes. You have made the PNRD party. But have you approached the PNRD for that? You want effectively a writ against the PNRD.
And it's a two, it is clear.
Understood, Mr. Lava. You want the writ against the PNRD. Can this court issue a writ when we have not approached these authorities? Have you approached them? Understood. You can make anybody a party, but have you approached them before filing the writ petition? Then, and that too in a representation which is not clear. That is why the Deputy Commissioner thought it better let me refer you to the Zilla Parishad. They let them understand.
Let there be a proper inquiry,
Inquiry for what?
ethic, education.
You are saying about the school. If it is a school, why have you not made the school authorities a party?
Health center.
The health center has to be, health department has to be made a party. If it is a health center, but these are not clear. You have made a very vague statement in your representation. Ongoing dispute with regard to the location of various government and non-government institutions. Where? Which one? The instant petition has been filed by the petitioner. Seeking a direction to the respondent authorities, upon the respondent authorities to consider the representation submitted by the petitioners. By whom? Who has submitted this representation? Thank you.
Gurdwara, Governor.
Submitted by any, and that is not a party. No, they are not a party. Submitted for consideration, for seeking a direction upon the respondent authorities to consider the representation submitted by whom? No, not members, by
Number one, Gurdwara Government.
by number one
Gurdwara.
Borjara Gaon Unnayan Samiti.
These are not some of the members.
And to cause a departmental inquiry into the grievances made by the petitioners. This court have perused the representation enclosed as Annexure 1 to the writ petition. The said representation on the face of it is vague and lacks material particulars. Under such circumstances, the writ which has been sought for under such circumstances, the relief which has been sought for by way of the instant petition for a direction upon the respondents to consider the said representation does not arise. Accordingly, the instant petition being devoid of any merit stands dismissed. Be that as it may, this court makes it clear that the petitioners, the petitioners who claim to be members of number one Borjara Gaon. No. Is that Borjara Gaon? Number one Borjara village would be at liberty to submit a detailed representation before the authorities concerned, setting out their specific grievances to start. And the dismissal of the instant petition shall not prejudice their rights.
Number 3.
Who are you?
not a different person. Please,
Authorized person for collecting the toll. Since what remains? No, that has that been extended? You must be given a right on the basis of that. Where's your right? Show me. Authorized to collect on behalf of the board of the year 2008, and you are therefore to deposit this amount. Then what remains? The period is over. Huh? Taking into account that the period, taking into account that the authorization which was granted to the petitioner to collect the parking fee had already lapsed. Had already lapsed. The writ which has been sought for by way of the instant writ petition cannot be granted, and accordingly, the instant writ petition therefore stands dismissed, stands closed as infructuous. Interim orders, if any, stands vacated.
or
This court have duly, the relief which has been sought for in the instant writ petition is that the instant writ petition has been filed by the petitioner for setting aside an order dated 13/1/2018, as well as also seeking a direction to allow the petitioner to ply the BOV within the Assam State Zoo premises until the completion of the lease period, that is February 2019. Taking into account that the period is already over, nothing survives in the instant writ petition, for which the instant petition stands dismissed. Stands closed. What is this, Mr. Ahmed? Huh? The houses of the petitioners. Then
Then my lord, the FIR of the thereafter, the petitioner has to discuss captain officer as well as the deputy commissioner, he is required to pay financial assistance money.
this is under what scheme?
My lord, this scheme atmosphere, just from the
Where is it?
in the bottom, my lord, serial number 3. SDRF shall be used only for meeting the expenditure for providing immediate relief to the victim of cyclone, flood, earthquake, fire. This is the fire.
How did the fire happen?
Fire happened, my lord, from in fire is infested, my lord, by electric shock. My lord.
Show me.
At fire address, I think, my lord.
Yeah, I have the honor to state that last on Iman, at Iman set fire in my CIC and CIC of my brother, nephew and Iman due to electric shock and destroyed the house. Let us read the Assamese version because it is in such horrible English. Even the dictionary will feel shy what it is.
Not to work directly with the basis of control direct letter control. In direct as it is, no one. 4:30 বাজার মোর ঘরত ইলেকট্রিক বিদ্যুৎ গতি ফুল লাগি মোর লগতে ভাই মস্তমালি ভতিজা কুমার আলী খালাপ সঞ্চল ভতিজা সাহার আলী কিংপাতক ঘর ঘরত থাকা নিম্নবর্ণিত বস্তু সঞ্চ যদি সকল সংযোগ করে
Then
Tell my lord,
is this a disaster?
tell my lord. Yes,
Huh? Show me how it is a disaster.
my lord, section 2B of the disaster management.
Yes, let us see. Because of disaster management. Act. What is this RG? What do you mean by RG? A fresh proposal of RG in connection with a fire accident in a new format and government instruction. Yes, tell me.
Section 2B. Disaster means a catastrophe, means a calamity, great occurrence in an area arising from natural man-made causes or by accident.
Which results in substantial loss of life or human sufferings or damage to and destruction of the property or damage to or is of such a nature or magnitude as to beyond the coping capacity of the community of the affected area. Mr. Roy, you file your affidavit as to whether this incident will come within the ambit of disaster, because this is very relevant. The instant writ petition has been filed by the petitioner claiming compensation in terms with the notification dated 27/7/2011 from the State Disaster Response Fund on account of the properties being destroyed, properties of the petitioners being destroyed. Due to an electricity incident. Mr. S.S. Roy, learned counsel who appears on behalf of the state respondents, is directed to file an app. Who shall file? Who is going to pay? Revenue. This disaster management is under your control. The Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department is directed to file an affidavit clarifying as to the incident which had occurred for which the compensation has been sought for would come within the ambit of Section 2D of the Disaster Management Act 2005. So as to entitle this aspect of the matter is very essential for the not only for an adjudication of the instant dispute, but also as regards the compensation claims made under the scheme. The said affidavit be filed by the instant repetition is directed to be listed on 8th of November. The said affidavit be filed by 6th of November. Because this is required. Otherwise, but I know the revenue disaster management is not going to file it. They don't want the filing in these types of matters. And at the last moment, this court has to grant it. That day, another matter of next of kin. Would a nephew be entitled to claim benefits under some Assam Agitation Fund on account of his uncle who was unmarried having died? And the revenue commissioner and secretary kept quiet. So that this court passes an order on the basis of presumption, no, they are entitled. Yeah. Next.
There is a continuation matter in respect of another matter. In the year 2013, anarchy is belongs to belongs to anarchy. There is a notice.
Yes, Mr. Das, what are you challenging? What is this order which have been challenged? What is this order of 31/5/2013? Why have you challenged that for 5 years? Why have you challenged that for 5 years? Huh? Show me that order 31/5/2000.
That is page 95 matter. But edit to proceed with the additional proceeding matter because the land is now converted to in the name of the garden matter.
Hmm.
And after that,
Letter of friendship I pleaded for making in my after careful examination action of the payments of the land in Dolbet the minimum bargaining utility state and statement in the land is now tell me, who are you?
I'm the owner of the matter.
And you want to throw somebody out?
No, that is it. That actually originally when the land was taken over by the bank,
It was?
It was free money, free from all enterprises.
Then
Then it was taken over, but subsequently it was again he converted, he become bit to
and in the meantime, some encroachers entered.
They have occupied money.
And the direction is now that you have to approach the competent court.
But that is the order.
And by this time, another 10 years have gone by.
No, when the land was taken over by the revenue department, it was a free land. There is no anybody matter. It's a completely free from all enterprises.
But how can now, but Mr. Das, how can now this court direct the deputy commissioner to throw them out when the now land belongs to you?
No, when the land was originally taken over by the government,
Go before the land grabbing authority. There is a land grabbing proceedings. Why you are not initiating that? Why will the deputy commissioner now? Because this directing the deputy commissioner here will be giving a handle to the deputy commissioner to do many things. Every time they will be doing it. No, I have understood. Your case is that during the fixation of 1970 Sealing Act.
That's actually like.
So they have taken this land and later on, when they made the correction or anything happened, the sealing proceedings was removed, the land was returned back to you.
Right.
In the meantime, the encroachers entered.
Right.
So now you have to throw them out.
Now, only matter of fact,
10 years have already gone by.
Government duty on the part of government to hand over that, this free, that they say, free from all the information model. Now, it is for their fault, they emphasize that occupy the land model.
Have you made the encroachers the party?
That will be.
No, if this court, Mr. Das, they directs the deputy commissioner to throw them out.
No, it's by police, due process of law.
What procedure? What procedure? Now that the land does not belong to the deputy commissioner.
No, even when the original land was taken over by the government, it was 3 years. Free for all the information, there was no enforcement, my lord. Now, in the meantime, when the land was taken over and the record was corrected, every record was corrected by saying that we shall never occupy, my lord.
Because
Now,
here, what you are asking now, this court has to presume. Can they now take action under 18.2?
My lord.
Can they? Can they now take under 18.2?
Because actually now, when the record is.
No, Mr. Das, there is no problem. This court, I am of the opinion they can.
Right.
Under 18.2, they can, taking into account that they will verify and do it.
Right.
But if I allow them to do here, you know the deputy commissioners, they will do everywhere.
No, but-
Everywhere, every case, they will step into it. At the hands of the public, because as of now, the land belongs to you.
Not for the next deed allocate 38 months, just time, during the allotted attention, my lord.
You want the position to be restored back
My lord.
to that position.
But that's when land was. The word to that, revenue department, my lord.
Difficult.
Because the original, this act is not applicable, my lord.
We check.
This act, that's chilling act, my lord.
Understood?
My lord.
That is why the land has been returned back to you.
My lord.
Now, in returning, there are some encroachments.
And for your mistake, also,
They can pay you the cost of compensation.
No, at this moment,
They cannot, this court can't direct them.
Already been initiated, my lord, for addition of this inputs of fire. Take back from another D, my lord, page 38, my lord. You also get a day of already directed. Yes, just after something of check to drop a proceeding, my lord.
Where?
Page 38, my lord. This is the order passed by the, it is Lana additional deputy commissioner and General Mongol, my lord. My lord. Last part of the case, my lord. On speaking of the records are released orders passed by the additional deputy commissioner and collector. I am of the opinion that an area of 260 bigas, was in a certain period above and records were corrected accordingly as seen for time. Hence, as area of 260 bigas, covered by the number 8 of number 2 first letter of the Bahipupuri, Bahisha and registered in favor of the Bahipupuri feature and records be corrected accordingly. The subdivision of which are shall hand over the area covered by that was transfer and correct the record in favor of the Bahipupuri feature and a copy of the order be sent to the subdivision officer. So, then last part on the
We are only concerned with 22 bigas.
No, but the entire land, madam.
Huh?
The entire land of 260 bigas, madam.
No. 22 bigas. Kindly see Annexure E, page 45.
That is the Saturday extent here report.
Out of 216 bigas, 16 letters of land which was taken over in addition to the law, above law by the government. 193 bigas, 4 kathas is under the possession of the estate, but 22 bigas, 1 katha is outside. It has been illegally occupied by 8 people.
Madam.
This is the circle officer's report.
That was the report.
And why haven't you made those people parties?
Right.
Why? Very difficult. Mr. Das. We can do another thing. We can issue rule. Already 10 years have gone, let another 10, 15 years go. The best option is to file a suit or throw them out. Or land grabbing nowadays. Now the land on the face of it, on the basis of these documents, it is clear that the land now belongs to you. And these are the 22 other encroachers.
Only the record, every record is corrected, madam. By
Understood, only 22 bighas out there, why you are not throwing them out by filing land grabbing cases? And instead of doing out here, this court cannot.
Only I mean, such a people also, because when the land was, at the time of taking over the land, there was a complete three land, madam. The debt portion is to be divided back again to the owner, madam, to the estate, madam. Is a boundary duty on the part of the revenue authority, madam, to give a the land.
No, are you admitted, is it your admitted case that 198 bighas have been given back to you?
No, only the record is corrected, madam.
No. Possession out of 216, 198 has been given to you.
No, madam.
That is what has been mentioned
But
in the circle officer report.
my entire land is now, actually, we have it out of possession, madam. 216 meters, madam.
Yes, file your affidavit and in your affidavit, mention how many bighas are there. Then one can do one thing, this court can direct you to, if it is only 18, 19 bighas, give some other land to them, 18, 19 bighas, matter is over. Keep this 18, 20, then throw them out as government land, recorrect the records. This is how you can do. That is the best way out. If it is because the circle officer's report only shows that 193 bighas have been returned to him. And out of that, 18 bighas are in occupation, 22 bighas are in occupation of these people. So under such circumstances, if it is 22 bighas, 22 or 21, these land can be very well, the records could be very well corrected, given them that land, some other 22 bighas, and these 22 bighas be made government land, and then throw these people out, exercising 18 to.
That's my last page of the regarding 216 bighas Korean class land covered by the number 8 of the state T-shirt. It is seen that although the state land is in the name of the T-shirt, the same is not under possession. But that has not really by the cycle of the melon. By his letter, the 8/6/12, madam. But from the earlier thing, 8/6/2012, last month report of 21 because this is the letter of the cycle of the melon.
That is also the circle officer's report, the earlier one which I said. Okay. The the deputy commissioner of which? Mongoldoy. Udalguri. Dorong or Udalguri? Because if page 103 is seen, it is given to the deputy commissioner of Udalguri. In which deputy? And have you made the deputy commissioner of Udalguri a party? Then whom have you made parties? See, you have not made the deputy commissioner a party.
In my time, it was corrected by it was corrected by Udalguri.
Now Udalguri I see, but why have you made the additional deputy commissioner? You have not made those other persons also a parties. If this court passes an order, those other people will be affected. How can this court pass a writ
The order is passed by the input order is passed by the additional deputy commissioner of the madam.
So
That's why, sir, for that, actually,
additional deputy commissioner have passed the order because he is the, amongst the, are you challenging the additional deputy commissioner's order? Yes. If you, that is, you are challenging, go to the Board of Revenue. And you are not making the deputy commissioner a party. But if you are on the other question, that look here, they have taken the land wrongfully, returned it free of, which was free of encumbrance, and now they are returning it with encumbrance, with people remaining there. Then it is a different thing, but there you have to make the deputy commissioner a party.
and this is my, I will find this program.
A perusal of the instant repetition shows that the concerned deputy commissioner, that is the deputy commissioner Udalguri, is not a party to the instant proceedings. It is also seen that while challenging the order dated 31/5/2013, a writ has been also sought for a direction upon the respondent authorities to evict those encroachers. The said encroachers are also not made parties to the instant proceedings. Mr. N.C. Das, the learned senior counsel, submits that he would take instructions in the matter, list the matter after the puja vacations. Think about it, land grabbing is the best. That is the only way out when you are having all the materials. But if you keep on delaying it by filing this, because you moved after 5 years, another 5 years has gone. We are in 2023, 10 years have gone. It will be more prejudicial to you. Think about it. At the end of the day, you are not going to get the relief. I'm giving you a guarantee on that. I may put it 101%. But you are not going to get. But you may only get the benefit by which you have to move the land grabbing. Yes, next.
7.
Yes. The Learned Counsel appearing on behalf of the petitioner, Mr. S. Thakur, submits that the petitioner's grievances have been duly taken care of and as such would not like to press the instant petition. Accordingly, the instant petition therefore stands closed and infructuous in interim order. Huh?
Eight and 9.
Yes.
Number 8.
8 and 9. Yes. What is this?
East Counter Center.
Huh?
East Counter Center. Stage 9, Barnacular, there is that.
On giving effect to the order dated 6/2/2018 issued. What is this 6/2/2018?
Page 9 of the Barnacular. That copy is page 7 of the, there is some error in the petition.
Page 9.
Page 9.
No, which petition are you referring to?
Page
I-
991.
Okay, what are you challenging in line 9?
This letter by which I have been asked to,
Why there are two petitions challenging the same?
there are, I am representing in this petition, there are 2 petitioners also. This is serial number 2 and
Or petitioners are different? Okay, what is that order?
8.
Yeah, regarding shifting of fish selling auction center. Hereby informed that yes, as per the order of the High Court in the above mentioned matter, you are requested to shift the fish auction center.
This is not
From where?
okay, from, it is a Bhola Bazaar. They are saying it is within the, Debut Saitya.
Otherwise, you will be evicted and you got to stay. And you are now running it inside the Dibru.
It is there is a market. Only we have been asked to see.
Others are running.
Others running. Market is there
Yes, who is appearing? This is done by the forest.
by the forest.
And the forest is not represented.
There is my affidavit of council.
Okay,
This,
the instant, both the petitions have been filed by the petitioners, challenging the order dated 6/2/2018, whereby the range officer Soikwa Wildlife Division, Na Bormura, had directed the petitioners to shift the fish selling auction center to some other place, as the place is, as the present location of the fish selling auction center is inside the Dibru Soikwa National Park. This court, by an order dated by various orders, by its respective orders in both the petitions, have issued notice on (23/2/2018). Same order, na? And state and directive maintenance of status quo as regard the soft premises of the petitioners. Although a stay has been operating, the Forest Department have not cared to file any affidavit in opposition or even represent file it. It is also seen that the Forest Department is also not represented when the matter has been called for. Under such circumstances, list the matter in the second week of January 2023. The interim order so passed shall continue till the disposal of the petition. A copy of the instant order be sent to the principal conservator of forest for due attention about the order so passed. Huh?
Our name is not reflected.
Not reflected?
Not reflected. GS.
Yes, what has happened then? Huh? Name is. In 2018, you had the Forest Department. Then how can your name be reflected? So then you tell your PCCF when this order goes there. Yes, Mr. Nath.
We have also filed an affidavit. They did not record the competition of the award of the arbitration. And the letter sent to the NHAI.
Now, who is going to pay the interest? The Deputy Commissioner. Who is going to pay the interest because of the delay? Because the award was passed in 2014. The amount has to be paid from the date of taking over the possession. Who is going to pay the interest? Are you, you being the state, are you going to bear the burden on behalf of the NHDCIL? Because they are not going to do that. Or should it be collected from the salary of the officer?
The present officers, he has joined the office on 7th of September.
Okay, from the present officer, you collect it. From the earlier officer, you collect it and give it. Because the interest will be 15%. It's not a matter of joke. It will run into some more than a few tens of lakhs. So it will be deducted from their salaries because why should the state bear these expenses? Or if the state wants, very well, we'll take it as their statement, being the senior government advocate.
No, but the deputy commissioner has no business in this case.
Absolutely, the deputy commissioner had the business when the competent authority had, the arbitrator had directed the deputy commissioner to do it, not the deputy commissioner, the competent authority to do it. It was her duty or his duty to do it. This was given in the year 2014. Then here we see the deputy commissioner, they just keep the applications under section 18 for making a reference or under section 12 for making a reference just in their in their custody as if it is their property, but they don't realize that what is the consequences thereafter. The compensation has to be paid at a rate of 9% from the date of taking over the possession, and thereafter for the rate of 15%. And it's a huge compensation then, huge amount. Who is going to pay? Would the NHI, DCL will be paying? No, or NHAI. They would say, why should we pay? It is the fault of the deputy commissioner to do so. You bear the interest.
Delay is correct or delay at the time.
Delay for 9 years. Is it a matter of joke? Your collectors, competent authorities, deputy commissioners have taken these the land acquisition proceedings in such a manner that okay, as if they are giving this money as a grant to these people. You are taking their lands. There are various judgments of the Supreme Court which says that it is next to a human right. It may not be a fundamental right, but it's still a constitutional right. But I'm not worried about they will get the money eventually. But the thing is, the state is going to lose. Any money gone from them or you unnecessarily because of the lapses of the officers is public money. It comes from your taxes because of the tardiness of the officials. Now, how much you have computed?
5 years.
Yes, I've seen it. Yes.
The column number 7 says already.
In view of the above, you are therefore informed to make the above mentioned fund of rupees 12 lakhs 4,000 available either enhanced or can be released as per the assessment as so and so. Who has done this? Now, has she taken into account this 12 lakhs along with the interest?
This statement,
Where is that interest? To me?
statement is shown.
Ah. Ah.
The amount, column number 7 says the amount of the paid.
Ah.
Then Solatium of 42% above column number 7, it is shown. Now the interest is also shown.
What is this 9% business? Under what provision you are giving 9% only? Then, huh? No. The 9%, this 9% under what provision you are giving? This is done under the National Highway Act.
Yes.
Let us see. Okay, the relief which have been sought for in the instant repetition is limited to the compensation being adjudicated upon, which has now been done. Now it is the question of the NHA, DCL, or who is there, who is to pay. So you have to deposit this amount within a period.
But the 9% possible rate, the 9% they have taken from section 28 of the 1894 Act. Collector may be directed to pay interest on excess income to one direct line.
28, if you take it, it becomes difficult. 28, if you go, first year is 9%. Thereafter, it becomes 15, see 28. Let us not go into that aspect now, because why I don't want to go, because this will lead to further complications. The prayer which has been made, they have done it. So you, within how much time you are going to pay? You have to forfeit. The moment they do it, you have to forfeit, because again the interest will accrue. Within 3 months, 6 weeks, you deposit it so that the disbursement can be. Both the repetitions are taken up for together, taking into account that the relief sought for same award, huh?
Same.
Is the award the same? Same award. Okay, I come in 10 minutes, huh? An order taking into account that the relief sought for in both the repetition is the same. It appears from the perusal of the pleadings in both the repetitions that certain lands belonging to the petitioners were acquired under the provisions of the National Highways Act 1956, or short, the Act of 1956. Pursuant to the said acquisition so carried out, an order was passed under section 3D, 3G of the Act of 1956 by the competent authority. The petitioner, being aggrieved, had approached under 3G at 5 of the Act of 1956, and the learned arbitrator had passed an award on 29/8/2010 29/8/2014. Directing the competent authority, thereby disposing of the said proceedings with direction and directing the competent authority to recompute the compensation on the basis of such directions and pay the compensation accordingly on the basis of such assessment to be made. The petitioner thereupon had approached the competent authority on numerous occasions. But the directions contained in the award oblique order passed by the learned arbitrator dated 29/8/2014 were not complied with, for which the incident both the repetitions were preferred by the petitioners, seeking a direction upon the respondents to expedite the matter of compensation in terms with the directions specified in the order dated 29/9 or 8.
Okay, lordship has indicated in the last order as 29/8.
29/9 in the repetition, it has been mentioned in 29.
They have mentioned that.
Hmm? 29/9 8 on 29/8/2014 passed in case number RR 80/2012 bracket audio WPC number 3435/2018 and passed in case number RR 61/2012 bracket WPC number 1130/2018. This court, by respective orders, issued notice in the year 2018, and thereupon it is seen from the records that on 25/8/2023, when the matter was listed before this court directed the competent authority, who is the additional Deputy Commissioner Kamrup Rural, to place before this court by way of an affidavit the computation pursuant to the awards dated 29/8/2014. However, when the matter was listed on 28/8/2023, the said affidavit was not filed by the competent authority. This court duly observed in the order dated 28/8/2023 that the award so passed by the learned arbitrator on 28/8/2014 in case number RR 61/2012 and in case number RR 80/2012 were not put to challenge by the NHAI, and the delay in computing in carrying out the computation in terms with the award dated 29/8/2014 would be prejudicial to the NHAI, as it would lead to accruing of interest on the enhanced amount. Under such circumstances, the competent authority That is, the additional Deputy Commissioner Kamrup Rural was directed to place before this court by way of an affidavit the computation pursuant to the awards dated 29/8/2014. And the matter was directed to be listed again on 8/9/2023. The record further reveals that on 8/9/2023, when the matter was listed, the council representing the competent authority gave a lame excuse for being not able to comply with the directions passed by the arbitrator. By filing an affidavit to an affidavit in WPC number 3435/2018. However, in WPC number 1130/2018, the competent authority did not even care to file an affidavit. Under such circumstances, this court gave an additional opportunity to the additional Deputy Commissioner Kamrup Rural to place the computation arrived at on the basis of the awards before this court on the next date, failing which this court was on the next date. That is today. The record reveals that the competent authority, that is the additional Deputy Commissioner Rural Kamrup, had filed affidavits in only one case.
Sorry, one case, we have filed, not 1130. And this, we have stated in that affidavit, for both the cases, competition has been done. In fact, but we filed.
I filed an affidavit. In WPC number 1130/2018. In the same affidavit so filed, at paragraph number 3, the competent authority stated that the compensation amount in respect of the petitioners in WPC number 1130/2018 and WPC number 3435/2018 were duly computed by the competent authority. And the statement of computation of the compensation amount dated 14/9/2018 as per the award of the arbitrator dated 29/8/2014 was sent to the project director NHI PIU Guwahati by the communication dated 14/9/2023, directing them to make the fund available for necessary action for release of the said amount. In the same affidavit, the communication so issued to the project director NHI PIU Guwahati had been enclosed as Annexure A, and in Annexure B, the computation so carried out pursuant to the award passed by the learned arbitrator on 29/8/2014 in respect to all the claimants, that is the petitioners herein, in case number RR 80/2012 and case number RR 61/2012 have been duly mentioned. Taking into consideration the Annexure A as well as Annexure B, which is the consolidated statement. The relief which have been sought for by the petitioner have been duly addressed to. This court, however, finds it also relevant to take note of that as the competent authority have now made the computation on the basis of the award passed by the learned arbitrator, as could be seen from Annexure B to the affidavit filed in WPC number 1130/2018. A statutory duty is therefore conferred upon, is imposed upon the central government, and in the instant case, the National Highway Authority of India, in terms with Section 3H of the Act of 1956, to deposit the said amount with the competent authority so that the competent authority would be in a position to disburse the said amount. Mr. C. Bulwer, the learned counsel appearing on behalf of the NHAI, submits that 6 weeks' time may be granted to the NHAI to deposit the said amount in terms with the computation as reflected in Annexure B to the affidavit filed in WPC number 1130/2018 by the competent authority. The competent authority, that is the additional deputy commissioner, is present in the court pursuant to the order passed by this court on 8/9/2023. The additional deputy commissioner submits that upon receipt of the said amount from the NHAI authority, the same shall be disbursed to the petitioners within 15 days. Within 15 days thereupon. Taking into account the above statements made by the learned counsel for the NHAI authority, as well as the competent authority who is present in person, this court therefore disposes of the instant petition, directing the NHAI authority to deposit the amount as reflected in the computation enclosed as Annexure B to the affidavit filed by the competent authority in WPC number 1130/2018 within mistake, no? Within 8th of November, on or before 8th of November, and thereupon the competent authority shall disburse the said amount to the petitioners after making due verification and after making due after carrying out necessary identification as required, necessary identification and taking into account such and taking such, they have to submit an indemnity bond, madam,
Actually, by the,
if they can. And after necessary, after carrying out identification, the necessary identification, and on submission of the required papers. With the above observations and directions, the petition stands disposed. I hope, Mr. Rava, now you get something. The personal appearance of Miss put the name so and so, the addition and deputy commissioner rural, who is also the competent authority, is dispensed with.
12 and 13.
Yes, Mr. Borgoya.
They have filed the affidavit, my lord, which means that the earlier stand they have taken, same stand they have taken also now. And they said, my lord, section 47 has been complied with. If it is so, my lord, what you will kindly have a look,
What 47?
only 47 CRP. 47 to provide, my lord.
Oh, this is arresting somebody after dusk.
Yes.
Woman
No arrest has been made, my lord.
alleging police atrocities by respondent numbers upon a woman that too after dusk.
My lord.
What atrocities?
Atrocity, my lord, I was pushed and they have entered into my bedroom. Police officer, male person allegation is there, my lord. They have filed their affidavit, my lord. The same affidavit reflected, because section 47 was, I like to know, was it attention, CRP.
Now, say it.
47 subsection 2, my lord, how it is to be done, my lord. Proviso is clear.
Now, what do you want?
My lord, I make a prayer, my lord, from,
For what? Don't tell me you are making a prayer for compensation.
no, my lord, I'm not making of that.
What do you want?
I want, my lord, one case has been terminated, one has been executed. The two affairs are there, okay, one has been terminated.
Search of a place entered by a person sought to be arrested. If yes, 47, which one?
47 subsection 2.
If ingress to such place
Proviso.
cannot be obtained under subsection, it shall be lawful in any case for a person acting under a warrant and in any case in which a warrant may issue, but cannot be obtained without affording the person to an opportunity of escape. For a police officer to enter in a place and search therein, and in order to effect an entrance, need to break open any door or window, or so and so that the person to be arrested. Yes, you want to the proviso.
Proviso says, my lord, they have to give a notice, but this is very silent in their effect.
What notice?
My lord, yeah, proviso says, my lord, provided that any such place,
How do a person give a notice?
my lord, it is clear, my lord, also.
No, let us assume in that flat,
My lord, after sunset, so my lord, they cannot enter. Assuming for a moment, my lord, after sunset, they know it is only the setting moment, my lord, giving night around.
Mm.
And
provided that if any place is in an apartment in the actual occupancy of a female,
Right.
not being the person to be arrested, who according to customs
Right.
does not appear in public,
Right.
such person or police officer shall, before entering any apartment, give notice to such female that she is at liberty to withdraw and shall afford her every reasonable observer for withdrawing. So how does the notice, if she's inside a flat, how do you affect the notice?
They can keep my lord,
Where?
in my house only, my lord.
How?
They can keep my lord. House,
No, you tell us, let us, these are all
my lord, after
various
coming, my lord,
circumstances one may think about. How does a person give that notice? If a
Notice, my lord,
person
the
is
moment-
inside the apartment and you are outside,
My lord, the moment they come, my lord, they have entered, first door was not locked. Before entering, before taking their action as per the police action, they have to.
the house belongs to whom?
House belongs to both wife and husband.
Is it recorded?
It's not recorded,
Where? How do you know the husband and wife?
My lord, I had told me, my lord. both. I had.
No, somewhere it has, you see, in the actual occupancy of a female, the occupation has to be actually of a female. And there is another person inside.
My lord. Wife is there now.
No,
Husband,
is in actual occupancy. The actuality, the house or the flat should be under the occupation of a female only. But there is another person inside. So what do? You give a man notice. Then look here. You may withdraw. You may just keep yourself aside because you are not the person to be arrested.
my. I'm not.
That's all. That is the notice. But how do you give the notice? Where did you come out?
My lord, the moment somebody comes, my lord, generally, my lord, wife, mother, sister, was are. Okay.
And is the woman,
If the woman is the position,
she is in the, she believes in the Porda system,
my. Yes.
so she doesn't comes out in the open in public.
my lord, she does not. Because my lord, in the. see the-
Where is your statement in your affidavit, in your petition?
No, my lord, that I have not.
Then, isn't that the requirement that she does not come out in the public?
That's not it, that the petitioner being a respectable woman of the society and also being a president of 90 number, Randy Kaufman said.
Then, how do you bring the other part? That such person and does not appear in public.
I mean, in the night time, my lord, he would obviously will not come. In the night time, my lord, after sunset.
Now, was she to be arrested? No.
No,
The husband was to be arrested.
yes, husband is likely to be arrested or some husband might have done something wrong.
Okay, now the husband was inside there or not?
Not there.
Not there.
Okay.
Huh?
Not there, not there.
Could not find there.
He was not there. I am happy with my minor daughter and daughter's daughter.
Then how do a person give a notice?
But the noticing given, I think they can give minor, but.
That no notice, no, tell me, let us review. How, that they will send you a notice under 41A
The
types.
moment they have come and knocked the door, they open, suppose the wife open, they have to give the notice, we have come for this particular purpose. This is the notice, what we will say. Then she says, okay, you.
No, what do you have to say now? Would you like to withdraw?
Oh, yes, I like to throw my note.
So that opportunity was not
We
given.
have not given notice was also not.
Notice was not. And notice means written notice.
Any my note.
So didn't they ask them that
But they
would
asked-
you like
they
to?
asked me, my lord. They asked
Isn't
me,
that a
like,
question of
they
fact?
caused- They caused me, my
No,
lord, that
Mr. Bobby, wouldn't that be a question of fact? But anyways, what do you want at the end of the day?
End of the day, my lord, I made a prayer, Rocky, you can read down to page 14.
840.
14 is the my prayer.
Written to make an inquiry on the respondent and to initiate departmental actions against the erring police officers. To direct the respondent authority to act upon the complaints made by the petitioner and the annexer so and so without further delay. Yes. So this is the year. Now, what have you done as regards this? He must have submitted some representation. What have you done to that?
I have an extra. I have an extra.
And what have you done to that? That is what he wants. You can't keep it. You have to make an inquiry. Huh?
Nothing has been found is that you can give the paragraph 10 of it.
Huh?
Paragraph 10 of it.
And what is the other petition for?
Other repetition, my lord, other way. The other case, my lord, since they have said, they filed a charge sheet or filed a report that is not.
To hand over the case of Hazo Police Station and Hazo PS to
If they have
any other
completed my-
superior investigator and
That
investigators.
case has come over.
You are the accused.
No, no, other person.
Who is he?
Yes, sir. I am the son. The other person, my lord. Other person, my lord, three person.
And charge sheet has been submitted in respect to which case?
Abdullah, Abdullah, Bibi, and other.
Let us see the charge sheet. What is the affidavit stand?
That case will not survive, my lord, if that should not finally.
Hazo states that as per office record, Hazo PS case number relates to an FIR lodged by one Mahima Bibi alleging assault. Case was investigated and final report submitted. That was lodged as, and what is your husband's name?
Anwar Hussain. Is the second
In,
next division, which I sought for to be investigated by some other.
so the accused is the second petitioner.
Yes.
He wants a proper investigation.
Yes, but it could be referred to some other independent agency.
Why?
Because my lord,
That they are not, there will be a bias.
they are doing favorism to the persons who are having political matters. I made a categorical statement in paragraph.
An FIR was lodged by one Sumi Begum, wife of Ansar Ali of Swansea, alleging assault based on the FIR and the Iman. Charge sheet number Iman was not. There are no materials on the court to suggest the police have been number 6 and 7
Paragraph six.
did not act as per law and requirements obtained. UTMT of Swansea. Visited the house of the accused, namely Hanuman Hussain. Akbar Ali. In order to appeal them in connection with them. State era was in accordance with the procedure done to legal evidence of the action against the accused. The reason of the condemned the people.
The case matter is in serial number 13, my lord, 202803. There are three, my lord, I have stated why it's subjected to a writ.
Now the charge sheet has already been submitted.
Yes, but that case does not survive. This
So this case does not survive.
file. Of case we survive, my lord, what action they have taken.
Has the charge sheet been given against you? Huh?
In case, 23 inquiry was done. Report was done.
213/2018, that was closed. And 212/2018, that charge sheet has been given. Charge sheet against? WPC number 2803/2018. The instant writ petition has been filed by 3 petitioners. Seeking a direction upon the state respondents to hand over the case of Hazo PS case number 210, Hazo PS case number 213/2018, and Hazo PS case number 212/2018, to any other superior investigating agency and investigate the same in a fresh and fair manner. What happened to 210? From the affidavit in opposition filed by the respondent number 5, that is the Superintendent of Police, Kamrup, Rural Amingaon, it is seen that in respect of Hazo PS case number 210/2018, charge sheet number 103/2018 dated 31/3/2018 have already been filed before the court. In respect to Hazo PS case number 212/2018, charge sheet was also submitted on 31/8/2018. Was submitted on 31/8/2018 by charge sheet number 341/2018. In respect of Hazo PS case number 213/2018, the same was returned in FR by FR number 148/2018 dated 31/8/2018. Taking into account that the investigation has already been carried out, nothing survives in the instant writ petition, for which the instant writ petition stands closed as infructuous, as stands closed. Nothing survives to be adjudicated as well as directed in the instant writ petition, for which the instant writ petition stands closed. Monju Bibi. Yes, what steps have you taken in respect to the representation?
In the earlier declaration, they have filed a detailed report of that. Which 22 investigation was done by the page number 54 of the report. Here the result is 22.
Who is this subdivisional police officer? What is that? What is the rank? Mr. Bormia, have you challenged this document? Annexure A to the affidavit filed in the other case. Mr. Roy has been very clever to file it in the other case so that your attention is not drawn. They will not challenge this. This is your, it is on one hand, there is your statement, this is their statement. How can this court now decide? Tell me. No, but they say that it is not.
They entered into my house.
Is there a bar to enter into?
No, my lord, there is a housing atrocity.
So they say that they have done it. Can you see page 65? They're running page 65.
My lord, this which is done by independent agency, my lord, and not other than this person. My lord.
No.
Subdivisional officer, SP level, my lord, all the picture will be here.
No, this is a fact finding. Therefore, don't you think that you need to challenge this? Without challenging this, can this court do it? Or bring something on record that this is false, and for which there is a reasonable basis on which this court can issue a writ directing some other higher authority to look into.
Or my lord, I can give the reply also. The other case will be.
But your reply, can it overshadow this? Unless you show that this report is perverse. This court has to form an opinion.
My lord,
What you are asking,
my lord,
that let it be, an inquiry be conducted. And this is the inquiry which has been conducted. Right or wrong, it is otherwise a question of fact. Unless you show some perversity into this, can this court do so? So, see, is there any loopholes out there? I think you file either your reply or think about it, what is to be done. Because otherwise, I don't think there is anything. But you should have brought this in the other matter. You have brought this in this matter. Or your superintendent of police has nothing, doesn't know. And what is this subdivisional police officer? What is his rank?
according to me, my lord, it should be inspector then.
And he is investigating a case of a OC, of an officer in charge.
No, no.
What is this? What is this? Can he do so? That the Pranab Kumar Pegu, APS, and erstwhile subdivisional police officer Rongia was instructed to inquire into the complaint dated demand submitted by him before the Assam Police Headquarters, Assam. As per the inquiry, it was found that the allegations made by the complainant are all false and fabricated. This statement should have been made in the other petition. Why haven't you made it? Huh? Because this court I have disposed of this.
I will.
Then how do you bring?
But if not, that ongoing. This
And
is
how will you file it?
additional.
Isn't this a very clever thing you have done? To deprive the petitioner of filing it properly? Today, Manju Devi may not have any connection with Anwar Hussain. Isn't it?
And then-
That, the very clever thing, Mr. Roy. Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents, submits that an additional affidavit would be filed, bringing on record the inquiry report. So, inquiry report pursuant to the representation submitted by the petitioner. This court grants 4 weeks' time to do so. List the matter again on 10th of November 2023. The additional affidavit be filed by 7th of November 2023. This court further directs the respondents to disclose as to what steps the higher authorities of the police administration have taken pursuant to the said inquiry report in their additional application.
40.
Yes. To a fresh sale certificate of sale of actual bigger about 1 bigger, so and so. Further steps for registration. Yes, what happened?
This restriction was filed for registration of the sales. How many of the account was clarified that restriction will not be mandatory. Then the part, the bank has, idea, and they were typical questions will give. Normal, refunded my money.
You are the bank.
Oh, I'm the petitioner, I'm the auction purchase.
Sale has been done under what? It is done under the income tax rules.
No, that sale initial options are referring to, under the, done by the recovery of sale, BRT, under the RDP. Not under this. Here it is governed by the Surface Act.
So this is the sale certificate.
The sales certificate was issued to my favor, but later when I went to get it registered, the various defects in the land was imposed upon, not only character, the land's measurement was found to be much lesser. Still, I wanted to get for this, I insisted in very. Can you give me a fresh sales certificate, because the reduced that. But part of educating any such figures, they have not even deliver the physical question. Today, I'm expecting to say that the land is massively under enforcement. When I told them, even 5 years back, it's not. Even this declaration, the Wakalatana was filed on 1/8/2018.
Which Epic Bank?
The HDFC Bank, for number 4.
Oh, your entire thing is against the HDFC Bank. But can you maintain the writ against them? Huh? For what?
So they have either, they have two options. Either they have.
Who is paying for HDFC? Is they paying for HDFC? Okay, Mr. Eburwa appearing on behalf of the respondent number 4, 6 for an accommodation for filing the affidavit in opposition in the matter. Mr. A. Ganguly appearing on behalf of the petitioner expresses urgency in the matter. So taking into account the above, this is the matter again on 16th of October 2023. The affidavit be filed by 9th of October 2023. The petitioner in thereupon shall be at liberty to file their reply. Yes,
So sometimes they request to file.
one expired.
That I cannot say, they are sent in June, last June. 23.
And what about 2
Please provide. Please.
alive? The learned counsel appearing on behalf of the petitioner submits on instruction that the petitioner number 1 had expired, and as such he seeks for 6 weeks' time for the purpose of filing, taking necessary steps to bring on record the legal representatives of the petitioner list after 6 weeks. 16. What matter is this? Directly into compensation of 3 years for making inhabitable the Assam type building of the petition. What happened to your house? Huh? What? What happened to your house? Had constructed an Assam type L pattern building with a pakka veranda in either side of the building, and front and back and full size of the building is fully described in the sketch map. Started residing with the aforesaid man with flying colors. The respondent via power grid started construction of air transmission line by the said, and this line was hanged on the said building. Huh? Wanted to dismantle the said building as it is situated at a risky post under the so and so. Asking him to make an assessment compensation of the Assam type as referred to other below belonging to the petition. Is pleased to ask the LTC so and so, the person to that evaluation of the Assam type of when submitted in a month, which is estimated in a month, now cost is higher. Your that line, power grid line was hanged over your land, by your house in the year 1995. And you have filed the writ petition in 2018. My goodness. Instruction for what? To make it infructuous. Have you got that amount? 1,33,000. You have not paid it.
I pay for the APD this assessment.
Who is appearing for?
APDCL is not a party, it's not a necessary party. We have not constructed the line.
No, I understood. You have nothing. That is why I have nothing. I thought that you were appearing for the power grid.
Okay,
What about the power grid? Who is appearing for power grid? Let's see. Affidavit in opposition has been filed with respondent number 3, 4, and 5. 3, 4, and 5. That is power grid. They are filed. Let us see what do they say. What is the name of the petitioner? Huh? Abdul Qadir Talukdar. You have already got the money in 1925. What remains? Why have you approved solely? Tell me. Why? No, tell me. Why did you wake up after 1995 and approach in 2018? And huh? Petitioner was? Where have you mentioned? Had met with an accident and had been bedridden and prayed for compensation for survival. But the authority is remaining silent. At present, if the building is to be constructed, about 20-25 lakhs is required. Where is it? The petitioner was unwell for the last 18 years. Where is it? Who appears for Power Grid? A.M. Doctor. Taking into account that the respondent, Power Grid Corporation, is not represented, this court adjourns the matter to be listed again after the puja vacations. They are not paying your fees for that. If they are, then what is there?
70.
I will it is a record, I will send you it.
Affidavit, when did you file?
I'm not receiving any.
You are going to file tomorrow morning or yesterday? I've asked you to file the affidavit day before. On 20, you filed it day before. For the cost. 10,000, you could not file the council. And as such, Mr. Council, you don't come to the court. You don't have a phone number. Then, what is all these things, making these statements? Could not find the council. And the council's phone number is glaringly shown out there in the files. Ms. A. Gayan, the Learned Counsel, appearing on behalf of the petitioner, respondent submits that the affidavit has been filed today. And taking into account the above, list the matter again on 9th of October 2023. The records, the registry is directed to bring on record the said affidavit. 6th of October. But madam, this is the first and last warning. Next time when I have fixed the date, I don't file cost. Cost of the costing starts from 7,500. I make it very clear to all the councils. Once date is fixed, if you don't file cost. Because the other side has to, today he has appeared, his client has to pay. Because of you, his client will be losing. So 7,500 next time would be the cost, which this court fixes on all councils. Okay. Yes.
But I love how I receive.
Okay.
Next, beginning is like this.
Mr. R.K. Musari, appearing on behalf of the BTC, submits. What is this matter about?
Well, the matter is relates to, actually, petition on having plot of land.
To restrain extraction of ordinary arts silt from the land of the petitioner covered by so and so found on the bank of river and adjoining areas for protection of Pokraja city as well as the Patta land of the petitioner.
He was not allowed to extract salt from the state land for his own purpose in the separate land. Subsequently, because of some joint verification.
Now, what do you want? To restrain extraction of ordinary earth or silt from the land of the petitioner covered by that number so and so. Yes, how can you do that? Can you do it?
I will see. Go to the-
Huh? No, he has filed the affidavit, he knows it. Can you do it? You may have a right under any minerals under the, but can, yes, these may be minerals, minor minerals, earth as well as silt would be minor minerals. But can you do in respect of a Patta land? Is it a government land?
No, the river bank. River bank.
River bank land. It is a government land.
No.
If it is a Patta land, can you do it? Report, does it say it to be a government land?
No.
Then Patta land, how can you do it? You want to delay the inevitable. You want to delay the repetition to be disposed in your favor. It's a matter after the Puja vacations, the respondents,
In the meantime, my lord,
the respondent, and it has been brought to the notice of the court that the BTC authorities had filed their affidavit. The petitioner would like to file a reply to the same. The said reply be filed in the meantime.
okay.
19.
Hmm. Whereby a resolution was adopted, the land measuring 3 kathas covered by so and so has been recommended to be allotted in favor of the Guwahati Municipal Corporation. Not, when not clear from the state as to whether pursuant to the state recommendation given by the special area, effective steps have been taken for the purpose of allotment of the land. Yes, any instruction? Has it been done? Your only prayer was that
Yes, my lord, and they are given the account.
possession, everything has been done. To allot so and so, because calling upon the respondent to allot lot number so and so and so and so. So it has been done. What do you mean? It will be given to the GMC.
But in the Shah, it was initially given to the petition and wrongfully given to the.
Understood that. Therefore, SLC had already taken a decision to give it to them. On the last occasion, Ms. M. Borman showed it to me that aspect. Therefore, but I say that from that document, it was not clear as to whether effective steps was taken for giving it to the GMC. Now, that is what I am saying here. This is given on 1/9. Let us see what is this. The committee approved the proposal by the resolution. The circle officer has been instructed to do the record correction accordingly. This was the direction. In favor of the Guwahati for setting up of the Masqua Fruit Bank. With regard, I'd like to say that an allotment proposal for the man in favor of Guwahati for setting up of the man of the committee has been approved and the proposal has been instructed to do the necessary right. No. It has not been done. Okay? This remains the same. Today, when the matter has been called, Mr. N. Goswami appearing on behalf of the Deputy Commissioner, Kamrup Metro, apprised this court and placed certain documents which does not, however, show that pursuant to the recommendation made by the Special Subdivisional Land Advisory Committee, steps have been taken for issuance of the settlement in favor of allotment in favor of the Guwahati Municipal Corporation. It, however, shows from the said documents that advanced possession, you got your advanced possession.
Later on, I think the land for land that has been allotted to the people.
Now it has been made in here. Who is in possession? That is going to be corrected. Possession, are you there? You are in possession. It has also been reflected in the said communications that the advanced possession had been handed over to the Guwahati Municipal Corporation. Be that as it may, the said instruction is not in terms with the query so made by this court on 21/8/2023 as to whether any further steps have been taken for the purpose of allotment of the land in question to the Guwahati Municipal Corporation pursuant to the Special Subdivisional Land Advisory Committee's resolution number 9 in favor of the Guwahati Municipal Corporation. What? No, there's nothing to that effect. Under such circumstances, Mr. N. Goswami shall provide the necessary instructions on the next date as to when the allotment in respect of Dag number 508 old / 1069 new of village Pamohi under Ramsorani Moza would be allotted to the Guwahati Municipal Corporation. List the matter again on 8th of November 2023. You get your instruction. This is not the type you keep on doing it.
20.
Yes. What is this?
Relates to allotment of a plot by Lanka Municipal Corporation. Originally, respondent number 5.
Take action against the respondent for violating the service rules and further weaken the nature and character of the weaken in the vehicle. What right you have to run the shop?
Originally, it was with the name of my father. Now,
Stop under what provision?
municipality or not, they can lease out your lot.
Show me that condition.
Itself. Some municipal land.
You are referring to 63? 62 is municipal property. We are concerned with 63.
To power to purchase lease their land.
And that too with the approval of the state government? Can it be given for eternity?
So your also that is not. That cannot be.
Then what is your right?
So your also kind of the manner in which your also the allotment was shifted from me to respondent number 5. That is the case.
No, how was it given?
Because your also on the basis of the your also they say your also on the basis of the joint application made by me and the that person. Now I denied my signature there So only when they filed an affidavit of opposition, I came to know about that. I lost the FIR. Now, Your Lordship, the municipal authority filed an Your Lordship, affidavit in opposition. If Your Lordship go to the affidavit in opposition, you would say that that particular joint application, the signature that was put there, Your Lordship, does not resembles my signature. Your Lordship. It is by the municipal authority. That's my case. If it is not, it cannot be allotted to me, Your Lordship. It can be allotted to someone else. There will have to be some procedure for Your Lordship.
They have to do it by inviting an application from all interested persons.
Your Lordship, maybe Your Lordship,
But you don't have a right to continue for all time to come.
But it is not the problem is this, it is still in the joint name of the me and the respondent number 5. And respondent number 5.
No, that we will set aside.
Lordship.
The entire allotment being made in your, both of your favor, if it was not done in accordance with law, because everybody has a right to claim a right over the municipal properties, to apply, and they should be given. That day I passed one judgment in the case of Mr. D.P. Solia and all, wherein in 1954, Kharpet area, there was a shop which was given to one. Thereafter, he sold it to somebody else. Thereafter, he sold it to somebody else. And then the best part was the third person, who was one of the petitioners, he gave a rent to the respondents, private respondents. Then the private respondents stopped paying him the rent. Then there was a suit for eviction. The eviction suit was decreed in his favor. After decree, the first appellate court reversed it, which was confirmed by the revisional court out here. Now the municipal court board here was sitting in view of the pendency of that dispute between those two persons. And then one fine day, some chairman of the municipal board realized that what are they doing? Saying that he came into possession without any right, so let us throw him out. This was in 2011, after long litigation. So he files a writ petition, the respondent files a writ petition and says, how can I be thrown out in this manner? Stay. Then as the stay was continuing, the Kharpet area municipal board got fed up. Let us do one thing. Petitioner has a right, okay, no problem. Let us give it to respondent, those respondents. Then they have filed a petition, they will withdraw it. Then the petitioner comes, how can they do it? And this matter has been then pending from 2016, and it came before me. Then I asked, what is their right to remain for in perpetuity? No right.
No, Your Lordship, that is there, Your Lordship. But only thing, Your Lordship, once it is allotted to me, Your Lordship, in my name.
So,
No, Your Lordship.
no, you have to show me that if your allotment will continue for all times to
No,
come.
that is not the case. My case is, Your Lordship, somehow, Your Lordship, they brought in, Your Lordship, respondent number 5 with tax collector with them, Your Lordship. I am, Your Lordship.
No. That's a case where respondent number 5's allotment will go.
Lord.
If it is done illegal, that's another aspect. But for that, because of the fact that the signature,
Lord.
it was done on the basis of a document which actually does not exist, or not a viable document.
No.
That is another aspect of the matter. But what right otherwise you have, apart from, so the final direction will be that whatever allotment goes, and the municipal authority shall take a call and give it to somebody by following the due process.
If Your Lordship has already passed it, then Your Lordship on that, Your Lordship, then you have to-
Unless you show that your allotment, which is given, has given you a right to be there in perpetuity, or a permanent transferable heritable right is given.
No, Your Lordship, my case is this, Your Lordship. If Your Lordship, they decide to cancel, Your Lordship, then later on that will be different. Here it is not a case, Your Lordship, that they have cancelled my name, Your Lordship. They, what they did, Your Lordship, they brought in someone.
No. The moment I therefore set aside which has been given in their name, what happens thereafter? Does it revert back to you? There the problem. What is the consequences thereafter? unless you show me. In that case, I asked Mr. Solia as well as those respondents, show me a document by which any other right is there. Because if you want to do it permanently, you have to take the permission of the, what you call, the state government, as per 63. Otherwise, you.
There may be another issue. Once it is allotted. Now, until and unless it is cancelled, your lordship. Until and unless it is completely continued, your lordship.
Now, can there be an allotment in perpetuity? Because that is completely foreign. Because otherwise, if you see 148, you come to again to the 148 says it cannot be for more than 1 year or something. Then if you see the sale of pounds and mahals, there are markets, it also says it cannot be more than a year. 148 says about 3 years. Then what is the basis to continue for perpetuity? In fact, yesterday I was taking up one matter of the GMC. Interestingly, the GMC has been given out that municipal market. Now, can there be an allotment which can go for perpetuity? No, this is what is being thought everywhere. Because GMC, if you are doing it an exercise of your powers under GMC Act, 174 says that cannot be more than, fishing cannot be more than 1 year, the allotment, and it has to change thereafter. Now, if that is the law, everybody is going.
No, but the problem is that your lordship, if a shop is your lordship allotted to the name of a particular person, he starts a business there. If after 1 year, your lordship, you have to change that, your lordship. Probably that is why your lordship.
That is why, but can you have a right over that property? No. You can't, you only become a lessee.
Unless you are.
Now, can the lessee be in perpetuity? Depriving all others. And if it is in perpetuity, it has the same flavor of a periodic lease. So whether there is any provision in the Municipal Act to do so, no, unless you take the permission of the state government.
Now, there may be or not be general permission from the state government to the municipal authority. I don't have the idea. Your lordship. I have.
Okay, take it out the ideas. Let us have it after vacation. Find out all these things. This is the matter after vacation.
Or municipality can your lordship have.
Municipality, you are saying about the urban
Yes, but no.
housing, very difficult.
এইফালে অৰ্ডাৰ চিনি আছে ইচ্ছা কৰিলে পাৰে সোনকালে কিন্তু সেই ইচ্ছা কৰে কিন্তু আৰু কষ্ট কৰিব ইচ্ছা
Hmm? Petitioner, the learning counsel for the petitioner submits that he has instructions from the petitioner that the petitioner would not like to press the instant petition, for which the instant petition stands closed on withdrawal. The item last to item supplementary. Yes, Mr. Vachhaji, your man.
I know 56, so yesterday we have filed the.
Yes.
That paragraph 2, I. Parents of courts or that cannot be subject to the payment of traveling.
We are just proposing, we are not taking subject.
In proposal, it becomes.
Because there is not a single penny has been charged from the number one for maintenance of the child. Document is an mutual agreement. Nothing is there. Apply here saying if they cannot afford it, by
The judicial way cannot afford travel from the removal. Because it doesn't give salary.
flights are available.
It amounts to denial of the right between. It is a law. Did you forget on?
No. As regard the child coming, 50% both of you will pay. Or Mr. Vachhaji, that is my decision.
I can.
I'm not saying about the guardian. The child's visit, the child, both of you will bear 50%.
Then the child I there.
You'll pay.
It looks very odd. I want to see my granddaughter and what I have.
So you are willing to pay that amount for the
For the
expense, for the work.
You will the bill. You will pay it by.
The instant contempt proceedings have been initiated.
That order may be for finance.
No. There's nothing remains any further.
No, there remains.
No. Anything else, it is subject to the the proceedings you initiate there.
Order is violated.
If it is violated, we will see.
Then I have to come.
No, you have to come, but can you keep it pending for eternity?
Not return.
No.
This next day.
First of all, Mr. Vachhaji, this matter will end here. And then if you have anything, you may take it up out there before the year.
Why I'm saying that? Where then what? Forgive me. Very bad. All the time I have to come to. And the.
No, if you don't need to come to this court, there is a family court where everything can be settled out. Why are you initiating this contempt proceedings out here?
That is violated. That is the proper.
So the court has to look into, then in that regard, this court will look into as to whether there is a violation is willful or not.
Yes, that.
But you can't enforce an order passed by this court by any subordinate courts. If it is a violation out there, then we will take up any other course of
Will
action.
not depend the same and fair in the content. I have not come to enforce it. I think at least one or two occasions. can be taken. Yeah, up to you.
The instant contempt proceedings have been initiated. For violation of the order dated 16/2/2019 in Ms. G, in case number Ms. G number 8/2018, passed by the Principal Judge, Family Court number 1, Kamrup at Guwahati. Where is that order? 16/2/2019.
Page capitalized.
It appears from a perusal of the final order dated 16/2/2019 that the parties have mutually agreed on certain terms and conditions which were mentioned in the petition, which were mentioned in the joint affidavit filed by the petitioners before this court, filed by the parties before this court, filed by the petitioner and the opposite party in Ms. G number 8/2018. The said petition, the terms of the said petition formed a part of the order dated 16/2/2019. This court have also duly taken note of the said petition, the said affidavit, containing the various terms and conditions. The said terms and conditions were contained in paragraph 2A, B, and C. And as the same has relevance to the present dispute, the same is reproduced here in under page 30 and 31 of the CD. From the above quoted terms and conditions, which both the parties of the instant proceedings have duly agreed to, it reveals that in a calendar year, in the months of June and November, the daughter of the parties, the daughter of the petitioner and the respondent number one, would have to prepare and appear for her half-yearly and annual examinations. And as such, the daughter need not visit her father's residence and need not visit her father's bracket, the petitioner's residence in these 2 months. Instead, the petitioner would come to visit his daughter at her place of residence for any 2 days in a month, according to the convenience of the daughter. It was also agreed to that for the remaining 10 months in the calendar year, the daughter would visit her father, that is the petitioner, at his residence for any 2 days in a month for a minimum of 4 hours in a day, according to the convenience of the daughter. Care, it was also agreed that care should be taken that the daughter's visit to the petitioners never falls below twice a month frequency. It was also agreed to that the daughter would visit the petitioner at his residence on the day of the annual Shraddha of her paternal grandmother, which falls during Kali Puja in the month of November. The daughter further would be allowed to attend other social events and functions of importance, including funerals and Shraddha ceremonies at the residence of the petitioner when someone in her immediate paternal family dies in future, and in which the ward's presence is naturally, the daughter's presence is naturally and socially expected. It was also agreed to that the respondent number 2 herein may accompany the daughter whenever he can on such visits of the daughter to her father, that is the petitioner. It reveals from a perusal of the petition, from the contempt application, that the petitioner, no, that pursuant to the said order dated 16/2/2019 passed, and the terms and conditions agreed to in the mutual agreement, which was made a part of the order dated 16/2/2019. The respondent number 1 and 2 did not care to abide by the said agreement, said terms and conditions. And on the other hand, the respondent number 1 and 2 have created obstructions towards the compliance. Obstructions had made it difficult for the petitioner to meet his daughter. It is under such circumstances that the instant contempt application was filed. For initiating contempt against the respondent number 1 and 2 for willful violation, willful disobedience and violation to the order dated 16/2/2019 containing the terms and conditions, containing the various terms and conditions as agreed to in the mutual affidavit dated 16/2/2019. Where is the original affidavit? First affidavit. Twenty 19. No, 20. The record reveals that an affidavit in opposition was filed by the respondent number 1 on 24/1/2020. In the said affidavit in opposition, the allegations made to the effect that the respondent number 1 and 2 had obstructed towards the compliance with the final order dated 6/12/2019, 12, na? 6/2 or 6/12, 16/12, huh? 16/2/2019 have been denied. It was also stated in the said affidavit in opposition that the petitioner had been meeting the ward, his daughter, as per the mutually agreed timetable at his residence. However, after a few visits, the daughter of the petitioner refused to meet the petitioner and her paternal grandfather at his residence for reasons best known. It was also mentioned that the respondent number 1 never discouraged or obstructed the petitioner from visiting their daughter at her place of residence. It is also mentioned in the said affidavit by the respondent number 1 that she had been appointed as a judicial officer in Mongoldoy on 28/11/2019. And she was undergoing training at Guwahati since 9th of December 2019. It is also seen from the records that an application was filed before the Principal Judge Family Court, Kamrup Metro at Guwahati by the respondent number 1 seeking modification of the alteration of the order dated 16/2/2019 passed in Ms. G case number 8/2018. From a perusal of the said application, it transpires, which is a part of the record, it transpires that it was prayed that the order dated 16/2/2019 be modified thereby granting liberty to the daughter to attend the house of the petitioner herein as and when she desires, or alternatively, the petitioner may visit the house of the respondent to see the child, the daughter, as and when he likes or desires, and also to meet the daughter after the school being over, namely St. Mary's High School near Guwahati Club. The said application was registered and numbered as Ms. J, case number 133/2019. Houston. To the same application, so filed by the respondent number 1 before the learned Principal Judge Family Court, Kamrup Metro at Guwahati. The petitioner herein filed an application in the court, before the family court, stating inter alia that the same modification petition should not be entertained and be kept in abeyance in view of the pendency of the instant contempt application. It has been submitted at the bar that the same modification application is still pending in view of the pendency of the instant application. It further reveals that the respondent number 1, in the meantime, have been transferred from the post of the Judicial Magistrate First Class Dorong, Mongoldoy, to the Judicial Magistrate First Class Dibrugarh by the notification dated 19/11/2022. And presently, the respondent number 1 is functioning as what?
Judicial Magistrate First Class,
What is your name? Where is it?
that also finds the information. That we have filed on 14/12/2022. That enter in the same. They have written the running days or not.
Is presently functioning as the Judicial Magistrate First Class Dibrugarh. This court further takes note of that during the pendency of the instant proceedings, that the parties have been trying to settle the disputes as regards the visitation rights of the petitioner amicably. It is also relevant to take note of in the meantime that as the custody of the child is with the respondent number 1. And the child is presently studying in class 5 in Don Bosco School, Higher Secondary School at Dibrugarh. Certain difficulties have arisen as regards the compliance to the order dated 16/2/2019, taking into consideration the well-being of the child, as well to well-being as well as the education of the child. On 15/9/2023, when the matter was listed, a proposal was submitted on behalf of the respondent number 1 that other than the months on which the petitioner, that the child has to prepare for her examination, that is in the month of June and December. No, June and November, no? June and November. And taking into account the distance, the respondent number 1 would be ready to bring the child to Guwahati so that the petitioner can meet the child at his residence. It was also mentioned by Mr. B. Gogoi, the learned counsel appearing on behalf of the respondents, number 1, that it would not be possible for it would not be possible to bring the child twice in a month, as it would hamper her educational her studies to Guwahati, taking into account the distance and the time which would be required for travel from Dibrugarh to Guwahati, vice versa. This would therefore, by the order dated 15/9/2023, directed the respondents to file an affidavit bringing on record. Respondent number 1, respondents to file an affidavit bringing on record the said proposal today. When did they file it? The said affidavit was filed on 21/9/2023. For the purpose of the instant case, paragraph number 2 being relevant is reproduced hereunder. Mr. A.K. Bhattacharya, the learned senior counsel representing the petitioner, submits on instructions that he is agreeable to the terms mentioned in paragraph number 2 as quoted herein above, except that the petitioner is not willing to, except that the petitioner is only going to pay the transportation charges, expenses of transportation of his daughter, and not the accompanying guardian from Dibrugarh to Guwahati and their return. And the such expenses shall be paid, and the said expenses shall be paid upon receipt immediately upon the receipt, upon the invoice being furnished to the petitioner. The learned senior counsel further submits that this arrangement, as mentioned in paragraph number 2, is only agreeable so long the respondent number 1 is posted, is staying at Dibrugarh, and so long the respondent number 1 is with whom the daughter, under whose custody the daughter of the petitioner resides, is posted at Dibrugarh. The moment, it has been also submitted that the moment the petition, the respondent number 1 is posted at a nearby, at Guwahati or a nearby district of Kamrup, the said terms as agreed to, the respondent number 1 would be bound by the said terms as agreed to in the order date in the mutual affidavit dated 16/2/2019. Taking into account the above, additional affidavit filed by the respondent number 1, and also considering the well-being of the daughter, as it would be inconvenient for the daughter to travel twice in a month to Guwahati, this court modifies clause 2A of the mutual affidavit on the basis of the additional affidavit and the submission of Mr. of the submission of the learned counsel, senior counsel of the petitioner, to the extent that during till the respondent number 1 is posted at Dibrugarh, the respondent number 1 shall be bound, shall ensure that the daughter, shall ensure that the daughter of the petitioner and the respondent number 1 visits and meets the petitioner once every month the respondent number 1, in terms with the said undertaking as mentioned in the additional affidavit, shall coordinate with the petitioner before any such visit and upon coordination, both the petitioner and the respondent number 1 shall agree to a mutually agreed date and time. This quote further directs that the respondent number 1 that the petitioner number 1 shall bear the expenses, transportation expenses of his daughter from Dibrugarh to Guwahati and return upon the invoice being furnished to him. It is further observed that in case the respondent number 1 is transferred to any other location, is transferred to Guwahati or a nearby location, the visitation rights of the petitioner shall be in terms with the mutual agreement dated 16/2/2019. Mutual agreement dated 16/2/2019. Clause 2A of the mutual agreed affidavit dated 16/2/2019. Unless and until any other order is passed by the family court on the parties approaching the said court. Taking into account the above, the instant, taking into account above, this court is not inclined to further continue. Now, taking into account the above and the additional affidavit so filed by the respondent number 1, this court is not inclined to further proceed with the instant contempt proceedings. And accordingly, the contempt proceeding stands dropped. The parties are the parties would be at liberty to take such further steps as deemed fit before the family court, Kamrup Metro at Guwahati. Taking into consideration that the welfare of the daughter being the taking into consideration the well-being of the daughter. 22. Well-being and welfare. What is this? Allotment of land. And what is water resource doing? Okay. So cause is divided. What is this order? Huh?
Some instruction I have received, but it's not even complete. I don't think it's-
But what is that order? 24/7/2019. Yes, speaking order. Also seen the proposal submitted by the circular for settlement of land on the peruse and also peruse the order of the Honorable High Court. Now, I, Lakshman, do hereby reject the proposal as time bar. What is this time bar? Regarding settlement of 15 lectures.
So, applied your laws, as well as the amendment of it. Everything I-
Status quo order is there.
Yes. Yes.
And how much land you are in possession?
Actually, I had 2.8 letter already out of 15 letter has been allotted.
Then? How much land you are entitled to? Where is that? Where is the land?
One of the citizen has been possessed already.
Sibsagar town. Sibsagar town, how much land can you get?
2 quarters.
Huh?
2 quarters.
But in 19,
1 kata 10 lessons.
Already 1 cut of 5 allocate and what is in addition to that.
He'll only entitled to another 5 lessons.
And 2 quarters, 8 lessons is under his.
Want to file affidavit file?
Because it's.
Mr. Goswami, the learned additional advocate general, seeks for an accommodation for filing an affidavit in the instant petition. List the matter on 17th of November 2023. The affidavit they filed by 13th of November. Interim order passed earlier shall continue till then.
23.
Yes. What is this matter?
I substituted to my father's property.
Huh?
After the death of my father, I substituted to my father's property. And a patta was issued to me at page 19.
Then
Page 19.
what happened? You must be happy with the patta. Okay, then what happened?
Then what happened?
2019, madam.
Then,
There are nine. The bank authority of the Haplong branch, madam, they made inquiry. In the And from there, they were receiving loan, madam, they came to know that the name has been previously sold in name of private respondent. Private respondent name was sold, so this is the property of that father. And my lord, I came to know that some anomaly of
your name was not mutated.
It's needed, madam. Your lordship will see, page 19 is the pata,
Hmm.
and your lordship will see, page 20 is that, entry, madam. This pata reissue, renewing for a term of period of 30 years,
Hmm.
expired on 31st March 2014.
Hmm.
This was done in 2010, madam. Land measuring to pata, covered by periodic pata number 517.
Yes, what is the stand of the government?
Now, my lord, I am challenging that order, my lord, they passed into order, my lord, page 68.
Page
68, my lord,
58.
68.
68.
There your lordship will see-
68.
Yes.
Page 6.
Running.
Running page 68. Okay, yes.
Here your lordship
So
will
and
see-
so covered by periodic patta number which was transferred in favor of Sorup Khersa from his father by son of so and so from his father late Suresh by mutation case number is hereby cancelled. And the same is retransferred to so and so wife of so and so on payment of a 5 of rupees 20 as per affidavit agreement executed on 15/9/2019.
And your lordship now will see, this order was passed without hearing, without notice to me. They directly do it, my lord, at the office.
Yes, yes, who is appearing? You are there. What type of this, means their law is not there. Is it somewhere in the very forest, dense forest area these people have passed? Or is it in Haflong? Now, what type of order is this? On what basis have you transferred? Affidavit transfer. So, no, by way of an affidavit, can it be transferred? Let us forget about other things. That is why I say, is it in a very dense forest locality where you don't see the sun? Huh? Where? Page
Running rate
72. Running page 73. Wow. Is this the affidavit?
Very shocking, my lord.
One time of so, and in this, I have voluntarily handed over the possession of the land to COT. Onani came by, whereas here.
No, no, tell me. The registration act doesn't apply. Does the registration act apply? No registration. Transfer of property act.
On the basis of what the disability.
You are just,
I am doing it.
what do you have to say?
On the visa, this is land on lease of land. And the authority, it was lease for your.
No, 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 no.
Then,
Is this the affidavit on which the transfer has happened? That order has been passed?
On the basis of this, on the basis of.
Then what is there?
I have conveyed.
Yeah.
The describe of last one in the.
Eh?
The describe of the property, it is everything is here. Very shocking, my lord, that,
Now what else do you want? After puja,
no, my lord.
today?
Yes.
Today.
In the running, but I have given area.
No. This order which has been passed on the basis of these documents. And Mr. Council, for the end, it's what type of affidavit is this? No, forget about other things. The first page does not have a signature.
Signature.
Where? No, signature. Where is the signature? That is why I said, is this the one? I can enter anything. And you see, the last two pages will say something else. Yes. I have no any objection over the land, nor shall raise any. I am a permanent that I am a right title and possession of the land at Haflong measuring total so and so that I voluntarily handed over the possession of so and so where she has all the right to transfer in her name and also shall also have a right to obtain loan by mortgage of her. Write whatever you want. Eh? R2? Your affidavit. Did you come document silent? I'm thinking that as vacations are coming, I'll only take up urgent matters. What is there? Lawyers also, they don't want that I should take up all these matters. I think that let he be happy for some more time. What do you say? Eh? Highly. Yes, what affidavit you are saying? The land measuring so and so covered by periodic patta is hereby cancelled. And the same is retransferred to so and so on the basis of the agreement. As per the agreement dated 15/9 by Miss case number dated so and so. Yeah. What is this? This is another agreement. Where is that agreement?
These election by attitude and XR to page 11.
Where is page 11? Oh, this form of periodic lease for land.
On the basis of that, if you get that affidavit, is a lease of the grant.
How can the authorities grant the lease in your favor when the land belongs to him?
But the affidavit is there on the basis of that.
What affidavit? The affidavit says on the basis of some agreement, some affidavit. Their case is some affidavit. Your case is on the basis of an agreement. Now, whose agreement between whom?
The agreement is a kind of agreement.
Understood. The agreement between whom? Periodic lease granted. This is the lease which has been granted pursuant thereto. The land measuring so and so. Respondent number 3, Secretary, North Kachar Hills. In this connection, deponent states that the land measuring 2 kata 5 lakhs covered by periodic kata number 517, which was originally belonged to so and so. It is mentioned that inadvertently the said land was transferred in his son, in Iman. While passing the said order, some relevant documents were not placed, and as such the concern passed that order. It is herein to be noted herein that during the lifetime late so and so had executed an affidavit date before the magistrate at Haflong, right number 15999, wherein he had voluntarily handed over the aforesaid land to namely so and so. In the said affidavit, late so and so had also given the right to transfer the so and so. And transfer the aforesaid land to so and so. Revenue appeal. Before whom? Have you challenged the order?
Yes, this basically order.
Where? Additional affidavit you have challenged.
Yes, I stated my lord. The order itself page 66, your activity. I paragraph 6. Page 56, paragraph 6. Running page.
Now, have you challenged this order or not?
Yes, my friend.
Where is it?
No.
There is no order you have challenged. Illegal entry in the record of rights erroneously maintained in the year 2019.
Therefore,
Illegally depriving the petitioner of here. You have not challenged all these things.
no, your lordship, I have taken order, that's the tendency.
By how have you challenged?
Paragraph 15, my lord, of my reading. I stated the order which was passed without my knowledge are liable to be set aside and passed. And this is the order without notice there that we that matter. Council itself. The lordship will see there is no whisper notice or hearing. There are 15 your lordship will see. There are case 30. The petitioner says next page 14 your lordship.
So what order should I pass?
This order case 68.
No, what order, Mr. Burwa, I should pass? Tell me.
If the revenue officer order is set aside. and
No, but can I set aside if you have not asked for?
I have asked for my lord. And
Where?
I have stated that I came to know from their education that this order was.
So isn't it required for you to amend?
So I annexed that order my lord in my insurance. Because they have never disclosed that. My case was that because my order.
So the moment you got the additional affidavit, why haven't you amended or filed the writ petition thereafter?
So therefore in my additional affidavit I have stated that. The language is that my lord. That illegal entry my lord.
Mr. Burwa, the matter is a simple matter. But because of this being not there, it becomes more difficult for this court.
I understand, but the order they have not communicated, no notice was issued to me. It was filed.
No, okay, now would you be happy if I pass an order that the illegal entry in the record of rights erroneously maintained in the year 2019 in respect of land measuring so and so in the name of performer respondent without officially declaring the same illegally depriving the so and so without following a act and disclose in writing the correct entry from the record of rights and further be there to rectify the records of so and so. Now let us see who is the performer respondent.
Performer respondent is, money.
Mr. Counsel, how can you are asking your main claim is against them?
Yes.
And you make them performer.
Performer is, at that point of time, the revenue authority did not disclose me that my land has been.
After you have come to know, does he remain the performer?
No, that would mean that.
Then you are asking a relief against them. And you are making them a performer.
No, they find that it is. They are contested that. I only submit our issue
Your only submission is this court. But would you be satisfied with the prayer made in the writ petition being granted? Would that suffice?
a Molnar relief, I paid for that. This order passed by settlement officer, revenue officer, page 68. That is absolutely shows that without hearing and without.
But that order is not subject matter of challenge.
That is what I'm challenging, I will tell case. Additional.
No, Mr. Borua, why should I help you out? Tell me, give me a good reason. If I help you out tomorrow, these people may say, all other lawyers will say, you are Borua, I am Borua. So they am helping out. Huh? Then
I don't mind.
give me a good reason, why should I?
My patta is there, my.
Oh, Patta is there, but you have not sought for setting aside those orders. Anything you have not. But how does this court pass an order, tell me? I even marked it to pass the order today itself. But how do I help you?
This is of my regional affiliated document, with my parents, government in page 66. Only other look at 66.
I've seen that.
Illegal entry is what I said, madam, relate to the order passed by them. That is the illegal entry they maintain in the record of that. And that is the order of which I have, madam. That is right.
Okay.
Otherwise,
Okay. I'll allow the petition. But subject to cost to be paid by you. Of 10,000. To the Advocates Association Fund. What do you say?
can you please follow?
You don't have a case. I'll pass the order. No cost, but I'll pass the order, set aside everything. This is not the way. Who is paying for a municipal bond? You. You are paying for whom? Lahore. The instant repetition has been filed by the petitioner. Seeking a direction upon the respondents for payment of an amount of ₹5 lakhs, along with interest at the rate of 12% per annum, with effect from 5/9/2017. The dispute in the instant case has arisen. The facts, as could be seen from a perusal of the materials on record, is that a construction committee was constituted for execution of a work in various wards of Mongoldoy town under the Integrated Housing Slum Development program, IHSDP. For the year 2015-16, in terms with the Mongoldoy Municipal Board's resolution number 9 dated 9/1/2017. The petitioner was awarded a contract for construction of a brick drain from Begamu Namghar to Bakuli Das and Bhola Das house of Mongoldoy town, Pustak. The said work was duly completed on 4/9/2017. And the petitioner claims to be entitled to an amount of rupees 5 lakhs. However, the respondents having not paid the said amount, the petitioner had approached the Mongoldoy Municipal Board on various occasions. The above endeavor on the part of the petitioner before the Mongoldoy Municipal Board, before the authorities concerned, that is the Mongoldoy Municipal Board, did not bear any fruitful result to the petitioner, for which the petitioner had filed the instant writ petition seeking the relief as already above stated. The said writ petition was filed on 13/2/2020. And this court, by an order dated 6/3/2020, issued notice. It reveals from the records that the executive officer, Mongoldoy Municipal Board, had filed an affidavit in opposition on 17th of March 2022, stating inter alia that it is a fact that the petitioner had duly executed the work as per the order. But the Mongoldoy Municipal Board was not in a position to make payment to the petitioner. On the ground that the earlier elected body had spent the amount on the ground of financial constraints. And non-approval by the concerned authority. It was further mentioned that a payment of the outstanding amount in respect of the work executed by the petitioner would be placed before the new Mongolda Municipal Board Committee that is to be formed after the election dated 6/3/2022. The Learned Counsel for the petitioner submits that in spite of the said affidavit, the Mongolda Municipal Board till date have not paid the amount to the petitioner. I've heard the learned counsels for the parties and perused the materials on record. From a perusal of the materials on record, it transpires that the petitioner was allotted work and the respondent Mongolda Municipal Board have duly admitted that the petitioner had duly completed the work and is entitled to the amount of rupees 5 lakhs. However, on account of the restraint, on account of financial restraint and certain approvals not being granted, the petitioner had not been paid the said amount. It is also seen that it is on affidavit. The executive officer had stated that the outstanding amount in respect of the work executed by the petitioner would be placed before the new Mongolda Municipal Board Committee that is to be formed after the election dated 6/3/2022. And thereupon also, even after a passage of more than 1.5 years, the petitioner have not received the said amount. It is the opinion of this court that when the Mongolda Municipal Board had granted the contract to the petitioner and the petitioner had duly completed the contract in terms and conditions which have been duly admitted, the petitioner is entitled to the said amount, and non-payment of the same on account of financial constraint cannot be a ground to deny the petitioner of his legitimate dues. Under such circumstances, this court therefore disposes of the instant petition directing the respondents who is to pay. Respondent number 3. Respondent number 3 and 4. To disburse the amount of rupees 5 lakhs to the petitioner within a period of 4 months from the date a certified copy of the instant order is served upon the respondent number 2, 3, that is the chairman, Mongolda Municipal Board. It is observed that if the said amount is not paid, the petitioner would not only be entitled to resort to such remedies which is available to the petitioner for non-compliance of the directions passed by this court, but also would be entitled to interest at the rate of 7% from the date of the default.
28.
Fantastic.
Consider our presentation. Allotment of the land.
That is the biggest prayer which this court doesn't grant.
Which are not considered because of the pending of the case before the Congress. The case that in the meantime will-
Limited prayer is very bad. This, you see, to consider the representation dated 16/5/2017.
This petition are still allotted, they are land as persons allotted.
Whatever may be, Mr. Laskar, the Question is, this court does not grant that relief. The court may give you many other relief, but to grant that relief for consideration is very difficult. What other relief you want? Not be issued directing the respondent more particular to allot settle the land in their favor which are in their lawful possession in dark number so and so year. You have made the application? When? 2014. It has not been settled.
So after the giving the application, the government has informed that there is a case pending relating to this matter. They have verified, they have found our position, but they cannot allot because of the pendency of the case before the court.
Which case?
Find the case number. Case number 41 year old. This was the case that was pending, but in the meantime, page number 24, after giving our representation, what the authority has said before. Page 24. Page 24 is our application. And then at page number 25.
Prayer for allotment settlement of ceiling surplus land. Oh, this is under 16. Under 16 of the Assam Fixation of Land Ceiling Act. You are in occupation.
Page 25 was kindly for them. After about it is seen from the inquiry.
The following person applied for allotment of land for the ceiling surplus land, claiming that they are in long possession of land, but due to the pendency of the status quo of the prior petition cannot be considered at this stage. In due course, and as per the provisions of the land bank, the prayer may be considered the joint petitions means
Instead of also being that they are saying that there is a case pending.
what happened to that? That petition has been disposed of.
Number.
Well, what is the direction?
Doctor would kindly get at page 41 is start. The relevant paragraph is page number 43.
In view of the above, we disposed of with the direction of the respondent to examine the claim of the petitioner along with other interests pertaining to any right arising out of the land in question and thereafter pass order in the matter as may be necessary in the facts and so on. What matter? What was the case?
It was just one.
That the respondent had earlier taken over the land belonging to the petitioner, erroneously holding the same to be ceiling surplus. Although the respondents realized the mistake and returned the land in favor of the petitioner, yet in the meantime, a portion of the land had been encroached. Since such encroachment has taken place on account of the actions on the part of the respondent, hence the petitioner has submitted a representation. However, despite receipt of the said representation, when no action was taken by the collector, the petitioner has approached this court by year. Yes, what has happened pursuant to this?
Thereafter, your office would have made a representation.
No, your representation cannot be considered. You are the encroachers.
We are there, we are paying the land.
You are the encroachers. You are paying the what land revenue have you paid?
We are taking our revenue also because we are.
If that is the land in question, where is the question of land revenue? When you return the land, when the land has been, the ceiling has been removed and the land has been returned to the Hindustan Corporation, this company.
Okay, there are total 60,000 acres, 1,000 acres of land, out of which 10,000 they were saying. So when we find an application for infringement, they say that the land which we are saying it does not fall within the 10,000 acre land.
Where is that order?
Then there are availability of. But we have filed an application for infringement. At page number 26. And then they have filed a reply to that.
For the last 8 years, alleged to be in possession by the applicants for the last 8 years, and the respondent does not admit it. They denied the applicant land about 14 land for exclusion from this. No. This cannot be done.
Altogether, there are 60,000.
Has the government filed an affidavit? This can be, the government has to file an affidavit. You make it clear.
Yes, sir, this is extra copy.
Oh, fantastic. So this is a case where there will be a lot of complications here.
Is it also to consider record?
Who? You want this course to be a post box? This code doesn't give the consideration bill there. If I give a consideration, I have to find out that you have a legitimate right. Now, the moment that land is outside the ceiling surplus, then where will they give you that land? Tell me. They can't give you the land for that. Then in that case, if you are an encroacher out there, either you have to get a right Khatiyan. Are you a right Khatiyan MPT? So under the 1971 Act, you get your rights of ownership. But this cannot be done in this manner because here you with have you made the Hindustan? These people are party? No. Then
Could have not disputed with them, and they are also saying that our land does not fall within the land they are claiming about. They are claiming some 10,000 acres of land. Altogether, there are.
so therefore, are you asking for setting aside of the order where they say that that is the land?
So there is not a except no order. What I am submitting.
No, that is there. That is why it cannot be considered. It has been mentioned. Kindly see page 25. Miss S. Bolwal appearing on behalf of the Deputy Commissioner. Which one? Filcher, Kachar is directed to file the affidavit in the instant matter as to whether the petitioners herein would be entitled to allotment of the lands pursuant to the order passed by this court in dated 23/2017 in WBC number 856 of 2013. The said affidavit be filed on 8th of November. This is the matter again on 14th of November, 15th of November.
I can participate.
You give the extra copies, huh? The counsel for the petitioner is further directed to serve extra copies of to revenue is there. To the learned counsel, Mr. A. Bhattacharjee and Ms. S. Bolwal as by during the course of the day. Yes, who appears? Yes, madam. Taking into account the significance and its bearing on the legislative discourse, deems it well, the PNI should file an affidavit enclosing the state reports for the petitioner in a part. You have filed your affidavit.
My lord, this one from 28, my lord can fix the matter.
I told you today, when this court directs filing an affidavit, if you don't file, cost.
The last chance.
So I'm giving you, today I'm mentioning it to you. So you are there. Many other councils I have seen today, I've told you. Because this court otherwise does not fix a date. The reason of fixing a date is that so that the matter of the petitioner could be brought to a conclusion. If the lawyer does not help this court, why should I? You want, or is there any, you have too many space at your house that you want to keep those files hanging out there, or you don't want the new files?
Absolutely.
You want it.
Clear the-
Then why are you not clearing the space?
If my lord wishes to dispose of the matter in light of the report, inquiry report, my lord has asked us to sit down as an.
Mr. Counsel, this very argument was made on 25/8/2023. Then I said you bring it on record by way of an affidavit so that the petitioner can have a say. How will the petitioner will have a say? Mr. P. Hendick, the learned counsel appearing on behalf of the Corporation Department, seeks for an accommodation to file the affidavit and submits that the said affidavit has gone for vetting. Full stop. This court by the order dated 25/8/2023 had directed the Corporation Department to file the affidavit by 15/9/2023. However, the said affidavit has not been filed. Under such circumstances, this court directs that the Corporation Department shall file the affidavit without fail by 3rd of October 2023. it is made clear that if the affidavit is not filed, then this court shall impose cost of an amount of rupees 10,000 rupees upon the official concerned. List the matter again on 9th of October 2023. Oh. For the periodic.
33.
SCPNR. Yes, where is who? None appears on behalf of the petitioner on call. This court fixes this matter again on 20/11/2022-23. It is made clear if the petitioner is not represented, that the instant petition shall be dismissed for non-prosecution.
34.
Yes. Oh, have you got the amounts? How much? You give it to me. Then we'll see as to whether he has the right.
There are two accounts.
His basic thing is, if the amount is good, then we will find. Else we won't. Second year, Carlos, given you. You are doing the case for whom?
I am from,
Rupali Bhattakur.
yes,
Who is she?
wife of a,
Anil Ratan Bhattakur.
yes.
Show me, how do you show that she is the wife?
Working with education, I have also annexed a bill which has been provided by the Delhi High Court.
Rupali Bhattakur. Yes, take this. Give it. I continue. You can take. We can close it now.
Yes.
The Mr. KK, the learned counsel for the SBI, had in pursuant to the order dated 15/9/2023, have placed before this court the statement of accounts in respect of the two saving accounts maintained in the State Bank of India, Guwahati branch, Panbajar. The details of the said saving accounts have been duly furnished to the learned counsel for the petitioner. The counsel for the petitioner therefore submits that the petitioner would therefore not like to press the petition any further. Accordingly, the instant petition stands closed on withdrawal. Closed in view.
Okay.
35.
Let us may kindly be taken up from some other day.
Why?
Yesterday, I filed a affidavit on behalf of response number 6 about it. And a hearing on
What is this case?
number 6.
Mandamus cause upgradation promotion of Siman grateful. Why is this matter before this court? Unless this court specifically, has it been endorsed to this court? This matter is pertaining to regarding the incident relates to service matter of judicial officers of the sub. Accordingly, as per the order dated at flag A, the same is required to be placed before order. Then late. And what happened? These are matters to be specifically, oh, this came up, means specifically endorsed to me, being made to the learned counsel for a petition as to whether the respondent has joined the post of survey. He submits that he has already joined the post and is present, not inclined. However, the impugn order shall be subject to hearing. Yes, Ingenious appearing on behalf of the petitioner submits that he has already taken steps. Accordingly, let the matter be listed after completion of the learned counsel for respondent number 6. See. You are 6. Why are you asking for accommodation?
Yesterday, I have filed affidavit that may not be shared with the records.
This is a matter pertaining to what? Some solicitor, isn't it? Motion. You have filed an affidavit. You want to file a reply.
No, only yesterday, popular stuff.
Are you going to file a reply or not? You want to file a reply. The learned counsel appearing on behalf of the respondent number 6 submitted that an affidavit has been duly filed, yes, on 21/9/2023. The said affidavit, however, is not a part of the records. Mr. Swenso, the learned counsel appearing on behalf of the petitioner, submits that he would like to file a reply to the same, for which 4 weeks' time is granted. List the matter again on 15th of November 2023.
Certificate from the High Court is also required.
Who is the High Court?
From the pending matter,
Ms. S. Sharma. Kar agote liston ko yan. Kar agote likho. Liston so and so agote. Ms. S. Sharma, the learned counsel appearing on behalf of the Guwahati High Court shall also file the affidavit by 17th of October. The petitioner thereupon shall file their reply. If so advised.
36.
Yes, Mr. Sheikh.
Doctor, is regarding use of land, my lord, without giving compensation.
Without?
Without giving compensation. That the ACAJ, your office, asked for in this fashion, your office, they have filed a petition of filed this right. Now your lordship will come to face 34.
Now, first and foremost, why should I take? How many petitioners are there? Only 60 rupees you are paying. Why should I take it?
70.
Huh?
70.
Well, you have paid only 60 rupees.
My lord. You know, 40, I undertake to pay.
Pay. Then I will look into it. There is no urgency in the matter. Urgency is there.
Urgency is there.
What is there?
Because
All this while nothing has happened. What is this urgency? Why this matter has come up now?
Doctor, your lordship, our land has been taken.
Yes.
And they say that they did not use the land. They did not use this, and your lordship will take the PDPT in opposition. There are 7.
Yes.
So if they say that land is not taken, it is not used. In that case, my lord, there may be mistake that don't use the land.
Oh, this submission, I remember you made it very recently. Yes, yes, yes.
So why they?
And on that day, I said, okay, we will take it again on 28th. We will take instruction in respect to the affidavit so filed by the respondent number 3, 4, 5, 8, and 9. On behalf of the BTC submits that he will take instructions. Who has filed affidavit?
That this application will file, my lord.
By joint Boroto Israel.
3, 4, 8, and 9.
My lord,
Hmm.
in this project, 666 Patata million.
Hmm.
Out of 666,
Are
only.
found to have been affected for the out of the Iman, a total of Iman have completed the agreement as per the zonal land value as so and so. And the agreement with the remaining 320 of the out of the 6 are in progress. The secretary of Kala has to require the Iman. What agreement?
Agreement,
Your lordship would be pleased to see case 34.
my lord.
This is done under what provision?
Look, this is the notification, my lord. Yes. Case 34, your lordship.
Page 30.
Right.
Yes,
Annexure 1.
yes.
This is still provided that land is to be purchased by a purchase committee.
Ah.
But they are not purchasing, they are not doing anything, but land has been used. Land has been used. regularly.
No, they are entering into some agreement.
Yes.
No, my lord, with us,
My lord.
my lord, no agreement.
Huh?
With us, no agreement, and affidavit in the affidavit, it is not say. What about the
No,
petitioner?
they are going to do it.
My lord,
Yes.
they are
This is
saying.
going on, my lord. And we are not cooperating.
Or you don't want to give your land.
No, no, they are, why will not cooperate, my lord? Your lordship.
The
is the place to
circumstances
see.
didn't
This
go
is
to
a-
go.
this
Not
is a
there.
false
Who is,
argument.
no, who is Makibur Rahman?
Some of the difficult.
Then,
Only the.
All are affected persons, my lord. And your lordship would be used to consider. Actually. my
no, no,
lord,
no. What is this? You are going by this policy for purchasing. Why don't you acquire this land?
For extension of road.
Huh?
Extension of road.
Extension of road, do it. As by acquire the land if you want to acquire. Why you are not doing it? You have the provisions of the Assam Land Requisition and Acquisition Act, which you have been using like anything, making the 2013 Act useless. You are doing it, do it.
from
If they are not agreeable and you want the land, go for it.
That is our representation, my lord. They may take our land. We will giving compensation, and your lordship would be pleased to see. The zero compensation, rate of zero compensation is fixed by them. Land value is fixed by them, but they are not providing our. My lord. And they are,
My lord.
they were there using
Ready
the
to
land.
provide.
Huh?
Already ready. Next, 24 amount already received from acquiring authority. From first week of October, already going to the reverse. But they are not coming to the.
Why do you not absurd submission, my lord?
No, my lord, my lord.
No, they have stated on affidavit.
Sir, sir.
My lord,
They have stated on affidavit that you are not going.
yes,
Yes.
They have stated on affidavit.
my lord. Why, they find the affidavit,
Some of
my lord.
the
Your lordship.
petitioners assessment, my lord.
Every day,
Assembly.
every day they are getting some new plea, my lord. In the affidavit in opposition, they are not saying that we are not cooperating.
They are saying,
Yes, my lord.
no, they are saying in the affidavit in opposition.
No, my lord.
Yes,
they are not
out of
cooperating.
688
My lord,
persons,
Remaining is going on.
364 or 346 have cooperated.
Yes.
323 are not there and you belong to this
No,
323.
that is not the specific thing, my lord. That is not the specific. Our contention is this, my lord, regarding our case, they have not specifically said anything. Whether we are beneficiaries, whether in 324.
Go there, they will consider.
My lord,
Go there. How many people are here?
my lord, our representation is pending 70.
Go there.
My lord, no, my lord, our representation, your lordship. Representation.
I am not going to look into the representation of 73. I will only look into the representation of only one person. Give me the name. Let us go by the Devendra Boro. Yes, we will see the representation of Mr. Devendra Boro only. Because you have not paid the court fee for others.
In that case, my lord, I am taking undertaking, giving undertaking.
No undertaking. This court is not going to do all this.
I will pay, and thereafter, my lord, they will act on. That condition may be good.
No,
It
no.
is a question
First
of money,
you,
my lord.
first pay. No, why will they do? First you have to pay, then only this court passes order.
So, my lord, it will list on Monday, my lord. With the-
Ready.
Go there.
Only the very cost salvation matter of community is ready, why it is stated. Why it is.
It is stated clearly in the
No,
affidavit. See,
possible, see there,
kindly see paragraph number 5.
paragraph number 5, yes. Yes, ma'am.
The 60 rupees has already been spent. No more hearing for today. 60 rupees is spent.
Your lordship would be pleased to see. There are five specifically not say that we are not proper.
They say that 326 people are not, and the agreement with the remaining patadas of so and so are in progress. Go there. If you belong to the patadas, you go there. No, Mr. Singh, you go there, submit before the authority, and thereafter you file an additional affidavit that they have not done it. Let us take a call.
That may be provided in the order.
No, 60 rupees spent. That will be subject to payment of remaining. I will pay only I will give Devendra Boro can approach.
In the case, madam, daily matter, come on Tuesday, madam, on Monday. For tomorrow, I will pay.
Please.
Because, madam, we are fighting the matter after the April,
Mr. Singh, you are a seasoned lawyer. For litigation from April is too short.
It is a thing, madam, here construction is going on. But they say that no construction is going on our land.
Okay. We'll have it on. List the matter again on 29th of September. So in the meantime, the learned counsel for the petitioner undertakes to pay the deficit court fee. Mr. Musari, kindly instruct your people to help it out about these people. You know the name. No, Mr. Musari, you know these people. There are 73 names. They take instruction as to whether you have asked them the issued notice. If you have not issued a notice to them, I'm not recording in the order for non-payment of the deficit court. You issue them a notice to collect, come for negotiation or whatever. This will end the matter. Issue them a notice.
May I submit 2 lines?
No, please don't. 60 rupees is spent. Next.
37 for the.
Okay. Anything happened? Return the proposal in favor. I am directed to inform you that the area of land proposed for allotment of land in favor of so and so. In the class of land is wetland and recorded as reserved in the report. We are therefore requested to identify a suitable plot of alternate land for allotment in the name of T. Jila Thunwas Park, and submit the proposal. Now what is going to do? The Learned Counsel appearing on behalf of the Learned Additional Senior Government Advocate appearing on behalf of the contemners. Are you appearing for the contemners? Submits that the proposal which was sent initially to allot land in favor of the petitioner have been returned on account of the land being a wetland wherein no allotments can be granted. She further submits that in the meantime, the Deputy Commissioner, Kamrup Metro, have been instructed to submit a fresh proposal. along with all relevant documents as per the land policy of 2019. So an instruction in that regard has been placed before this court, which is kept on record and marked with the letter X. Taking into account the above, the instant petition is the instant contempt proceedings is directed to be listed on 8th of January 2024.
I've already taken the same for the number 1 and 2.
I have mentioned it later, I will respond number 3. So the following content is the plot of the element paragraph area. And also which is respond number 3 is paid in 40,000 to the municipality in the year 1995. About this, after the series of meeting associated petitioner, in the earlier occasion, you are not to the past order.
Here, no, Mr. Sharma, first and foremost, whether the steps are complete,
Yeah, you have not guidance with the order.
you are appealing for whom? Respond number 3.
I am.
Who is appealing for Golaghat Municipal Board?
Nobody has yet, we have also kind of with the order that was taken for 11/6/2018.
11/6/2018, and notice that the notice has been released of the respondent application may appear in the ID card should be in the application, the simply had already been received all the answers, so it will be- Taking into account that the service upon the respondents are complete, you have filed your affidavit.
I filed my lord. I filed.
Then what do you want now? Why have you mentioned it?
That is actually the case is from 2016.
Why haven't you filed your affidavit if you want to bring your stand and bringing the matter for unnecessary?
I forgot that I was on the impression that I had filed. But it is in my file today. I filed in the next month. It is just finally given.
List the matter, taking into account that the service is complete, list the matter for admission in the on 4th of December 2023. In the meantime, the petitioner, the respondent number 3 shall file the affidavits.
39. So, in front of the police matter by my lord.
First and foremost, why haven't you taken steps upon the respondent number 7 and 11? What? There are orders being passed by the Lozima court and you are not doing it. Huh? Are you going to take steps upon the respondent number 7 to 11 or not? 7 and 11. 7 addressee left without instructions, so return 10 and 9 and 10 and 11 not found. 7 to 11. 7 to 11, are you going to take steps or not? Huh? What are you asking for in this? What has happened to this Mankasa police station case? Has it been charged sheeted? Huh? Do you want to proceed against the respondent number 7 and 11 or not? 7 to 11. The learned counsel for the petitioner is directed to take steps upon the respondent number 7 to 11 by way of registered as well as usual by 29/9/2023. This court further directs that in the event the petitioner does not take any steps, the matter be listed on 6th of October 2023 in the column of no steps, and thereupon consequential orders will be passed insofar as the respondent number 7 to 11 is concerned.
For the matter of on that matter, it has report made.
Yes, what is this I business?
We had filed for asking for a stay of further construction of the building. Because from the report submitted by the GMDA, but it came apparent that there was.
Why the matter has been listed? No reply has been received from the petitioner,
In the IA, we have not filed the affidavit of opposition.
and in the main petition,
And in the
steps are complete. So we can fix it for final disposal in the month of admission. That is the best way. What is all these things doing? Okay, taking into account that the affidavits, the pleadings, the affidavit, taking into account that the steps, the service is complete, leaves the repetition for admission on 11th of October 2023.
41.
Is that it is to the enrollment in the bar council. They refused my,
Mr. Rafiq, Mr. Hussain, have you got that order?
yes, well, this, Rawalpindi court has.
No. That legal services. That legal services matter.
Oh, yes, yes.
Yes.
All right. I sent it.
Yeah. I've recorded your name.
Yes. Well, there's a Rawalpindi court order.
Hmm.
My lord, dated 13/6/2023, my lord. Then the copy of correspondence has been deemed to be stopped, my lord, because earlier.
Service is complete.
Yes, sir. But they have not replied, no, they have not entered a real.
Bar Council of India represented by its secretary.
My lord, this is regarding enrollment of the petitioner as an advocate, but it was refused.
Refused by who?
Bar Council as well as the appeal, Bar Council of India also. Because of that, it is the only contestant he has during his service as a railway employee. He passed LLB from Kolkata Law College. But he was posted in Guwahati, Rania, like that, my lord. And then this is his details. With due permission from the railway.
Who is appearing for Bar Council of Assam, Nagaland, Mizoram, Arunachal? Huh?
Nobody has.
So it is going ex parte?
Maybe my lord is,
My goodness. All these are members of the Bar Council of Assam, Nagaland, Mizoram, and the proceedings is going ex parte. Fantastic.
the Bar Council of India also has.
No, Bar Council of India is okay, but everybody is a member. You are also a member.
Yes.
Then, and it is going ex parte.
Personally also I have told my lord, I believe
Then,
that UAP.
who is the secretary of the Bar Council of here?
That doesn't give our name, my lord. That was the secretary there. The secretary just name, my lord, I can't say, my lord. But there one secretary by designation of the business is there, my lord. One secretary there.
We can ask him to be present. Okay. It appears from the records that the steps upon all the respondents are complete. However, none of the respondents have chosen to appear. This court is further surprised at the action of the respondent number 3 and 4, 2 and 3 more particularly. Inasmuch as the said respondent number 2 and 3 has their office within the premises of this court and have chosen not to appear. This court directs the Secretary of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim to be present in the court on October 6, 2023. The learned counsel for the petitioner shall produce a copy of the said order before the shall place a copy of the said of the instant order before the secretary of the respondent number 2, so that he remains personally present on such stage.
That's the certificate copy or an official correspondence.
Any order you give it to him, not a certified copy,
That copy will be furnished to me.
not necessary. Take a printout and give it to them. Nowadays it is available everywhere. Na? Internet, you can get it. 42.
And if there is silent, people by turning of the name, and that particular road infrastructure has not been paid out by us.
Hmm?
That road in Peatland, that is by another, this particular road is not constructed by us.
Who has made it?
Okay. Let's say the. Cover the, maybe I just said, CL over the drainage region.
You are not making it. Why have you made the National Highway a party? Because it's a highway.
Our land was not acquired.
By whom? You don't know.
Since I have no communication with the client.
Since when you have no communication with your clients?
Just after,
Just 5 minutes before?
no, just after filing of the case. 2017.
And after filing of the case, why are you appearing every time? In 2017, you have appeared. Then in 2020 also you are appearing and you have no connection. Tell me. You are respondent number 2. You have stated that you are not. The instant application has been filed by the respondent number 2 as applicant for striking out of the name of the respondent number 2 from the accompanying writ petition, inasmuch as the said acquisition proceedings for which the petitioners have sought for compensation.
Okay,
What is the challenge for compensation has not been the National Highway Authority of India has no role in the same. The learned counsel for the petitioner have also not been able to show in what manner the National Highway Authority of India had been made a party. So under such circumstances, this court, taking into account the application as well as the affidavit filed by the respondent number 2 in the accompanying writ petition, which is on oath, strike out the name of the respondent number 2 from the accompanying writ petition. The IA accordingly stands allowed. The registry shall duly take note of the instant order and make necessary correction in the records of the accompanying petition and also update the same in the CIS. Oh, vote ki does.
43-44.
Yes, what is this? Early hearing? What matters? You need early hearings in this court. People, you lawyers don't appear and do matters, and now you are saying for early hearing. Then he always tries to escape and he wants an early hearing. Why? Tell me.
There's a stay order operating method.
Ask for vacating.
What has happened since,
Who is appearing for a petition? You are the petitioner. And what is the other one?
similar matter, my lord. Same stay order for the same location. There's an interim order.
Which one?
October 2014.
6389.
That has been.
In the interim, the process initiated for KSK Atle through the advertisement dated AI state. The entire thing has been stayed.
But regarding that particular location. But there was an advertisement, he had responded to it. One
No,
of the-
where?
In 2012.
KSK outlet. No. Press advertisement was there for KSK as well. KSK outlet is the entire one. How many things were there? How many outlets were there?
That particular, regarding one particular outlet.
No, it is not mentioned anywhere.
It's not necessarily powered only, madam.
Where is it?
In my.
The matter pertains to Kishan Seva Area Vidya is the.
Outlet location which were not necessarily covered.
Who is there in this matter? You are there.
Not in the next matter, madam.
No, in the, this, where is the interim order is there in 6389?
Yes, madam, October 2014, if I remember.
No, who's?
Honorable Justice,
Who is the lawyer?
the property was there.
Ah.
The property,
It is for admission or rule?
rule was,
Where? I don't see a rule. No rule.
the other, I think the subsequent order dated 24/1/2018, where rule was. Yeah.
Where? The rule issued in 605,
In 605.
not in the other matter.
Both matters are similar and the day is putting over both for the same location. So both are tagged. So,
An interim order passed in that case shall also be applicable in this case. What is the case about? You ready?
There was a,
Ready? Take it up. Tell me. You still have time, a lot of time.
what happened was there was a,
Who is the petitioner? Then we know you are anxious to do the matter, but then also tell me.
there's a-
And now you are going to say that, Lord, I don't have the records.
what has happened is, we participated in an evidence.
Ah,
Then one of the candidates was rejected because a PRC was produced by him, it was only for irrigation purpose.
Hmm.
Now he approached this court saying that my rejection over that particular PRC. He was rejected because that PRC was for irrigation purposes and we said that it doesn't apply for your residence. So, there, notice was issued by this honorable court and it was also observed in the entry that it was open for us to consider this case if we go ahead with the remaining for the evidence for the other cost, remaining costs. But during the pendency of the case, we considered this the candidate. And when we consider this candidate.
taking into account the interlocutory application, list the matter tomorrow at 2 o'clock for final disposal. Oh, on Tuesday. Taking into account. Yeah, and I can dispose of it. I can dispose. This is an application filed for early hearing of the matter. Taking into account that the stay order is operating and thereby affecting the applicant. This court deems it proper for that deems it proper that the matter requires to be disposed of, requires to be adjudicated on an urgent basis. And accordingly, this court directs both the writ petition to be listed at 2 p.m. on 28/9/2023 for final disposal. Not necessary. Why should I? This is between you and me. How does anybody is involved? I hope you bring your records. I dispose.
45.
Complete. Service being complete leaves the matter for admission immediately after the puja vacations.
46.
Yoganese. Lodgement of court order is 82/2020. We have none is appeared on behalf. Today also there is none appears on behalf. Aji appear for. I for what? None appears on behalf of the petitioner. It is also seen that the petitioners have not appeared before this court on numerous occasions, as would be seen from as would be reflected from the orders dated (22/2017). From 17/11/2017, 1/6/2018. For which the writ petition was dismissed for default. On 1/6/2018. Thereupon, the petitioners filed an interlocutory application being IAC 1287/2022. The same interlocutory application, when listed on 8/5/2023, there was no representation on behalf of the petitioners. This court, for ends of justice, directed the matter to be again listed. You are there? Is this 46? Yes, tell me. What is this? You have not taken steps, you are not appearing. You are not interested. Then Why have you filed this petition after such a long time?
So if the Angus company was. So if the Angus company was not well, at that time.
Then? Why you are not taking steps now as per the Lozima court's order? Addressee left without the RTS no area.
On Monday.
The learned counsel appearing on behalf of the petitioner submits that he will take fresh steps upon the respondent number 6 and 13 by way of registered post as well as ED, usual, by 29, by next week. Taking into account the above, this court grants time to the applicants to take steps by 29/9/2023. Failing which, the matter be listed on 6/10/2023.
Then
Yes. Why? Tell me, delay of how many days? Huh? It was dismissed for default. Who is appealing for the other side? You are appealing for everybody?
No, 1 and 2, madam.
1 and 2, Power Grid. What is your case? Compensation. Did you challenge that order? Be under section 10 of the, under the Telegraph Act? No, Mr. Das, today there was one matter of Power Grid. You appear for the Power Grid. There was one matter of the Power Grid where none has appeared. That is item number 2. I was supposed to get it, dismiss it. There's an affidavit also filed by the Power Grid in that matter. I was supposed to dismiss, but as you have not appeared, I grant you time. That was a matter pertaining to some place where the initially 1995, the Power Grid line was done, and thereafter in 2018, they have filed a petition. 16, item number 16 up to this. Yes, what do you have? Any objection? He wants the restoration. This is the delay. But then also, can we take into account at the time of limitation on the restoration application? Now, in that item number 16 also, that is the point. I took up that point, but when the Power Grid was not there, so I didn't want. Okay. You want to file reply? Dismiss for default, let us see what is it.
Number 4 and 5, madam. This comes from Mr. Clear. If we handle about the file to the commissioner. Without the intimation that we can say, before ending up with the file, get your for default, long way.
What do you want? I'll restore it and dismiss it. Now tell me,
So then why is there a plan?
huh? Acquisition happened on a particular, what is the time limit? Hmm? Page? Yes. I've heard as Bharat Ranganda, I have heard him say that the unique so and so everything can be disposed of in terms with the order that can be disposed of directly to make the required assessment. The damage that has been caused to the because we have proven that depending on the outcome of the petition, so the guidance and the repetition of this program. Then, so thereafter the assessment was made. Huh? Then nothing done. What does the power grids? Who is responsible number 7? Why is the police involved? Why is the SP filing an affidavit here? How many petitioners are here? 9. And out of these 9 petitioners, how many have already received money? 3 of them. Others have not. So what do you want now? What is your prayer? To issue a return measure, proceed with the construction of the ongoing area only after payment of the compensation. They have already made. What relief is there? Tell me. Tell me, what is your relief asked for? To issue a writ in the nature of mandamus to proceed with the construction of the ongoing high voltage transmission only after payment of compensation to the petition. Compensation, everything has been done. Then
In fact, actually, in our agreement, we have said, if they are filed under section 10B, before that, instead of they have already filed it. They are actually in it.
tell me what can be done. You think about one line, if it can be done. These IOs will be dismissed. Giving you makes no sense. because your repetition has become useless. Can this court direct you? Or can this court direct the deputy commissioner before whom you have filed the application under section 10 to be referred to the district judge? Think about that. Huh? You take it, because that is the only way out by which you can be saved. Because this court even can't direct that, what you are asking. So what can be done? Because you are asking, nothing remains, and therefore the order passed by the brother Justice Suman seems to be not wrong. Because your prayer was not, already must have become infructuous by the time when it was taken. Because the power grid, your thing is not to have the power grid till payment. The power grid has come up. People are getting electricity, and now you are doing it. Right? The above two the instant to interlocutory applications pertains to condonation of a delay of 881 days in preferring the application for restoration of the writ petition, which was dismissed for default by the order dated so and so. And the other application, that is IA number so and so, is an application for restoring the writ petition. This court have also, while taking up the instant writ petition, taking up the said application, this court had also taken into consideration the relief which was sought for in the writ petition. That is, that the power grid lines should not be laid till the petitioners are paid their due compensation. This court have also, Mr. Encitas, the learning counsel appearing on behalf of the Power Grid Corporation, submits that the transmission lines, these are transmission, high power transmission lines, were laid as far back as on in the year 2014. And as such, the relief which was being sought for in the writ petition did not survive. And as such, and consequently, this court have rightly dismissed the writ petition on the ground on account of non-representation, and also taking into account the relief sought for. This court have also perused the applications and the grounds stated for condonation of delay, as well as the ground, as well as the sufficient cause being shown for not being present in the court. On the date when the matter was called up for hearing. The grounds so stated in the opinion of this court are not satisfactory. And as such, this court is not inclined to either condone the delay as well as also to restore the writ petition. This court have also duly taken note of that restoring of the writ petition would serve no purpose, taking into account that the relief which have been sought for in the main writ petition had also become infructuous. Accordingly, both the interlocutory application therefore stands rejected. Be it as it may, the learned counsel appearing on behalf of the applicants submitted that the petitioners had approached the deputy commissioner, had on wrong advice approached the deputy commissioner under section 10. Mr. Under section 10D of the Telegraph Act 1885 for enhancement of the compensation, and rather ought to have approached the district judge within the district, learned district judge within the district of which learned district judge within the district of which the transmission lines were laid. This court makes it clear that the dismissal of the instant petition shall not affect the rights of the petitioner in approaching the appropriate court under the Telegraph Act 1885 for redressal of their grievances if permissible under law. Nothing more than that. Too much. What is this I witness? Why is this I?
As well as the reconstruction process is also going on, I have said that next I came to director of justice to complete the reconstruction process.
Submit any other further document to complete the reconstitution. No, what is this I business?
I have said to direct the respondent authority to complete the reconstitution process in a specific time frame, and if they need some documents for that, ask.
Have you approached them?
Yes, madam. We in fact,
No, have you approached as regards the prayer made in the IA to them?
reconstitution proposal has been submitted with respect to that.
First of all, is the prayer made in the IA a part of your petition?
Reconstruction process, yes, madam,
Then why have you filed the IA?
to do it in a specific time frame, madam. Already
If that is the prayer in the petition, how can this court fix a time frame?
time frame was not there.
Then,
File that, madam.
yes, what is there? Admit that the process of reconstitution is going on and that can be settled by next 2 weeks. That was in 2022. Has anything happened?
When this IA was filed in the month of January, we submitted a proposal online. So they were defects we pointed it out. Another proposals were filed. So recently, in the month of August, the last was filed. Now the process is still ongoing, and what I have been informed lately that if this honorable court directs us to finish the entire reconstruction about their proposal, that takes time. And
How much time will you require?
6 weeks. And until that time, the stay order which is operating. Yesterday.
Is a stay order operating?
I,
Main petition.
4/10/2003. There was a show for granted to
Having regard to the, it is hereby provided respondent may go ahead and take a decision on the prayer for reconstitution of the Iman made by the Iman as well as of the Sukhana. However, even an adverse decision is taken, the same not be taken, given effect to the returnable date. And the interim order is being continued. Okay. It appears from the records that on 15/2/2022, the learned counsel appearing, senior counsel appearing on behalf of the respondent Indian Oil Corporation had submitted that the process of reconstitution of the petitioner's firm is going on and that can be settled by the next 2 weeks. Today, when the matter is being taken up, this court inquired with Mr. P. Bharadwaj appearing on behalf of the Indian Oil Corporation as to what has happened in as much as on more than 1.5 years before, more than 18 months before, it was mentioned that the same would be completed within a period of 2 weeks. The learned counsel submits that the said process is on and would be completed soon. This court have also taken note of that the instant matter has been pending since 2000 and there has been a delay in the disposal of the writ petition on account of the reconstitution of the petitioner's firm is going on. Before the respondent corporation. And as such, this court fixes this matter again on 17th of November 2023. The respondent corporation, that is respondent Indian Oil Corporation, shall take appropriate steps so that in the meantime, the reconstitution proceedings be completed within the state, within on or before the next date. The petitioner in that regard shall do the needful, shall also cooperate so that the said proceedings could be culminated on or before the next date. More than 6 weeks. In view of the order being passed in the main writ petition, the interlocutory application stands disposed. That is what you asked. The reconstitution of the time frame besides it. Which one? Which IA? Which IA? You have asked for reconstitution time frame. Eh?
2203 of 20.
Yes, next. Oh, yeah, I agree.
49.
Yes, what is this IA business? Where's file I? For what?
And there is the presidential reputation matter. This passport is very, while being is submitted that I have to pay this fee. And madam, you can just notice my by this item.
What do you want in the IA? Your IA is more fat than the reputation. Why?
I challenge this past notice method because the main distribution matter, we are taking the field by the rectified.
Mr. Counsel, how can you, in an interlocutory application, can you ask for setting aside? Tell me. I don't know. You can know. Can, by way of an interlocutory application, you ask for a substantive relief? Either you file a petition or file an amendment application. This is not the manner in which you do it.
That idea may be the part of this distribution.
Fantastic. No. You got to stay also. When it is not a part of the writ petition, then how can you get a stay? You vacate the stay.
Last order already.
Huh?
Already.
Last one is a-
Oh, shall continue till then? When did I vacate?
About 28.
28/8/2023. Oh, I did not extend. I didn't extend. I didn't vacate. I didn't extend. By whom? I hear every matter. That doesn't mean that we have heard. Interim order passed earlier in the next date. During the penitential and notice dated that we are demanding an amount that is disputing the approval that is the complaint of the You have submitted your reply? No, that is the reason why I vacated. Now I remember.
I have submitted the-
The interim order was passed on the basis that you will submit a reply.
When you submitted by your post, madam, by your registered.
No, they have not received it.
That I know when you-
Where is their office?
Office, my lord, office in the Guwahati, they submitted it.
And where does the petitioner come from?
Petitioner come from Farinband.
So they can come and file an interlocutory application at Guwahati, but they can't go and submit the reply at Guwahati.
At that time was very short, my. And when that was to be submitted within 2 or 3 days, like that kind of order. So that submitted.
This court directed you to file a reply. Have you done that? Did the court say to do it within 2 days? Then list the matter for final disposal in the month of December at the admission stage. Why is the CRPIO here?
But this I is going for registration of.
Why? This court have to restore. So. None has appeared on behalf of the registered applications then dismissed for non-prosecution. Then the interim order so passed non so and so then vacated. What is the CRPIO for?
That was filed against the petition, whereby my petition filed under order 40/27 was dismissed. Okay. We filed the petition that order 40/27 should not have been dismissed. It should have been taken along with the final appeal. Before hearing the appeal, the CRP, my petition was dismissed.
Then
And we filed this CRP.
but why should this court take it up? I have not done anything.
This,
I have today restored many matters which are of other courts. Now, what has happened in the meantime? Vacating. What has happened to the appeal?
appeal is still pending.
Pending. Why? We restore it at the cost of 10,000 we paid. $12,500. You will be asking the interim order to be restored. Isn't it? The cost will be 12,500. 2,500 for the interim order and 10,000. Okay, make it 15. Okay. This is an application for restoration. Are you saying that this court dismissed this matter at 4:30 after 4:30? Is that an allegation? Oh. Whoever has filed this affidavit. Taking into account that the matter has reached this court today after 4:30, is the matter on some other day. You have drafted, next time no more matters of yours after 4:30. Whoever else drafted this petition.
51 and 52.
That is the allegation that I have taken after 4:30, therefore it has to, isn't that the allegation now?
But the time hearing of the.
Mr. D. Mojumdar, there are two lawyers who are appearing out there. Whoever has done it. So for all your matters, your matter after 4:30, no lawyer. That matter will be taken up whenever that. Whoever it is, if your matters, none of your matters will be taken up before that. Yes, what is this for? Petitioner. You can allow for you. You can't give.
Both the corrected.
Huh?
Both the corrected method. Both is the same.
Same matter.
Connected.
Or duta pele pele. Huh? Allow for you.
53.
What is this correction you are asking? Huh?
The petition is actually 3450, but here in the IA.
Instant application has been filed for withdrawal of WPC number 3450 on the ground mentioned in the application. Is for apply. Okay. Hey, man, order to some main file. Who has done this? Where is that order? I confirm. Where's that? Come on, careful now. What you have done? Careful no लिखने की बात. You are passing an order in 345. So this is unnecessary. Careful overlap, no? The instant interlocutory application has been filed for correction of the order dated 7/9/2023. In as much order dated 7/9/2023 in WPC number IA Civil 2612/2023. A perusal of the said order dated 7/9/2023, it reveals that incorrectly reveals that there is a typographical error which have resulted in being mentioned typographical error which have resulted in the mention of WPC number 345/2017, whereas it ought to have been 3450, WPC number 3450/2017. Under such circumstances, the said typographical error which had occurred in the order dated 7/9/2023, passed in IA Civil number 2612/2023, is being corrected, is being rectified by substituting the writ petition number, that is WPC number 345/2017, occurring in the order dated 7/9/2023, with WPC number 3450/2017. The instant order shall be a part of IA Civil 2612/2023. I stands disposed. 54. Yes, Hussein. What is the problem? Oh, yes, tell me. What is wrong with this order?
Your lordship has directed the respondent to pay the compensation to my mother and the petition number 2. But my mother died in the year 2017 itself. My lord.
Then how are you entitled to?
Because my lord, I am the legal heir.
Legal heir would not be entitled to.
Yes, my lord.
No,
Yes.
show me how the legal heir will be entitled to.
Yes, my lord. In the petition, my lord, the Lord is next, my lord.
Yes,
Page 18.
yes,
Victim, my lord.
page 18.
Victim, my lord.
Huh?
2F.
Uh,
2F.
uh.
Victim means a person who has suffered any loss or injury caused by reason
Uh.
of the act or omission for which the accused person has been charged, and the expression which includes his or her guardian or legal heir. I am the son, my lord, of Bharat. So, my
The
lord, I-
victim or his dependents satisfying the following criteria. You satisfy it.
But-
How did you satisfy? Show me.
my lord,
Where is your application? In your application, have you made any satisfaction?
yes, my lord, I have,
What did you say that you are entitled to? Nothing else.
my lord, my.
Were you surviving on the basis of your husband, of your father?
Father, yes.
No. How are you affected? Because your father died as far back as what? When was the date of the father's death?
2002, my lord.
2002. Then what was your, how many sons and daughters were there?
Other sons and daughters also there, my lord.
Where? Why they have not filed an application?
Because, my lord,
Because I remember this matter, because this is a matter where it is clearly given.
Yes, my lord, there is a clear direction to the wife. Page 46.
To the wives only. Why you have not mentioned in your petition about that?
My lord.
That there is a clear direction to the wives?
But I have selected the.
Why haven't you mentioned that? The 357A, there is a clear categorical direction to be given to the wife.
In the notification,
Forget about the notification. There is a direction.
yes. my lord.
Why haven't you mentioned in your petition? And how you are entitled to? Show me.
Because I am the legal heir. my lord.
You are not, a legal heir would not be entitled to. He has to suffer. That is the criteria. Nobody gets it. Sorry. Nobody gets it. He has to be, to become eligible, he has to show that he has suffered loss or injury. How you have suffered loss or injury? Where you are in your application you have mentioned? Show me. Where is your application?
Page 49, my lord.
Page 49. Where, what have you mentioned? Show me.
My lord, in the bottom below, my father left Bharani died, left behind me
Hmm,
as dependent along with my mother.
hmm.
He was the only sole friend and.
At the time of the accused Bahar Ali, Amir Ali, so and so, pedophile. Where? My father Bahar Ali died, left behind me as dependent along with my mother.
Yes.
So mother will get it.
But mother has acquired it, my lord. Actually, it also have, written mother.
Then
Mother
Why haven't you mentioned that in your application? Have you mentioned it in your petition? That the mother expired? Have you mentioned it in your petition?
No, my lord.
Then this court finds no ground. This court is not going to do that. You have to be careful. This can't be done in this manner, what you have done. Are you saying this to be a typographical error? No,
Normal, that is why.
file a review.
That I have.
The learned counsel appearing on behalf of the applicant submits that, taking into account that the error which have been mentioned would not come within the ambit of a typographical or a clerical error, would not press the instant application and would rather prefer a review application, but review application who's taking into account above the instant application stands closed. However, liberty is given to the petitioner to file a review application within the confines of law.
55, I have, decided whether cash or direct are recommended.
No,
Not only.
you
for-
could not have done that. This is. 55. Yes, madam. Correction of
last page 21 tera আছে
page.
page number আছে
Where do you want the correction?
34 আছে
Page 34.
21
Yes.
divisional commissioner the central divisional commissioner আছে
Ah,
The agency, no such agency is found. That's why I was filed. So,
madam, you will do one thing. We'll issue notice on this. Okay?
yes,
No, there's a reason why. These arbitrators are no longer there. We will have that matter, not,
Yes, madam.
we will have it after, along with that matter, we'll have it after Puja.
But, okay, I the data officer, okay. Now, procedurally, instead of, officer has gone, like it will be done. May I get reduced, kept the priority of the.
I'm keeping it separately.
priority.
I'll have it just after Puja.
Okay, okay.
In the meantime, what has happened, you see, these divisional commissioners are not there.
Okay.
So under such circumstances, I'll have to correct it.
Because
This correction has to be there.
29 is there,
Huh?
29 is 20, under section 29.
Ah.
Here will also mention there is a.
Yes.
You have to correct that.
Because otherwise, you will be compared. So therefore, I have to correct this order. I will correct it later on. Let's first get hold of, there's another matter where I am taking it up, where the revenue authorities are taking steps for appointment. Now, what has happened, these divisional forest commissioners have been abolished. That is why it is not going. In fact, when I passed that order, then I remembered about this matter.
Actually, what happened, your lordship passed in order May itself, but our abolition was on 17/7/2003.
It's okay, but now it is not there, so it can't happen.
It will be very soon because our other cases also lordship passed in my NSI case also.
No, therefore, that matter has very important relevance, where I'm taking it up. Once I do that, then they will act fast. In fact, what has happened, there was one matter, it's a different matter. It's a matter that these type of issues never arise otherwise. In a tea state, 52 persons who are 76 years old. One day they were terminated. No notice, saying that you are old, we don't require. They filed reference. Reference court said, no, you can't do that. Because there was no standing order. The standing, and then they filed a petition before this court. When the petition was filed before this court, interestingly, we have a Standing Orders Act, Central Standing Orders Act, Industrial Standing Orders Act. it stipulates in the schedule the age of retirement. Now, what has happened? The central government framed a standing order. Assam government also has a standing order, but the age of retirement was not there. But in 1983, the central government had made out its standing order with the age of retirement. 85, Assam government made a draft standing order. And it is not yet notified. 85. Till date. Now, when that matter, that is a matter of 2011, came before me, I have taken it up. Now they are doing it on urgent basis. So I am keeping that because otherwise to finish up that matter wasn't the time. But that is a very important issue.
Yes, therefore, yesterday also, in the decision,
Mm.
where we did not their partner on it.
Mm.
And so I have disputed copy similar, it's of the file of, again, this, arbitration, Indian protection, that was the rule.
Mm.
Therefore, it's the way for the two decisions, I'll be in a Indian, but even,
What happened there?
no, NSA decision, although that we intend measure not to demolish it was there,
Mm.
but also after taking into consideration everything from this, how we do concern. So these problems are coming up. If I would not have been there, definitely a lot of people would not pass that on.
Yeah.
We definitely apart to administrator.
I would not touch it, but there is no other way.
Presently, there is no arbitrator. The publics are coming everywhere. And I said also lordship passes the orders.
This the matter. What's up? Yeah. At the time of taking up the matter, Mr. C. Bulwer, the learned counsel appearing for the NHAI,
And he said, what to do.
respond numbers 1 to 3, submits that
Process it.
at present, the office of the divisional commissioners have been abolished. And there is a move from the revenue department of the government of Assam to appoint an officer from the revenue department who would act as an arbitrator in terms with section 3G5 of the National Highways Act 1956. Taking into account the same would take some time. This court fixes this matter again on 8th of November 2023.
You intermediate.
I think by then it
Right.
56 or good.
No, 8th November.